So you lost the election. It happens. You may not have to stump for votes anymore, but you may have some things left to do before wrapping up your campaign. Let's take a look. If you filed a Form 470, the short form, and as long as you didn't raise or spend $2,000 or more during the calendar year, that's it. You're done and have no more filing obligations for your campaign. But if you filed a Form 460 and your committee is still open, then you do have to keep filing a Form 460 and keep paying the $50 annual fee to the Secretary of State until you close your committee. If you're not planning to run again for this or any other office, and you need to close your committee, make sure it's not getting contributions or making expenditures, and won't in the future. Make sure there's no money left in it. Make sure you've filed all the required campaign statements up to that point, and that you've disclosed all reportable activity, including how you reached a $0 cash balance. And make sure there's no debt or there's no intention or ability to pay off the debt. Then file your Forms 410 and 460 marked as termination statements. Generally, within 24 months of being defeated, candidate committees must terminate. If you have questions about your termination requirements, or if your jurisdiction has adopted its own contribution limits, contact the FPPC advice line at advice@fppc.ca.gov. Now, if you have campaign funds left over and you do want to run again for this or any other office, you will need to transfer or redesignate the funds before they become surplus. Remaining campaign funds become surplus 90 days after the last day of the post-election reporting period. But before transferring funds for your next election, be sure to file a new Form 501 called a Candidate Intention Statement for that specific office. As always, make sure to check the Fair Political Practices Commission website. You can find our candidate disclosure manuals for state and local offices, which provide more information on this topic. Go to fppc.ca.gov. And better luck next time. This video is intended to be a general guide and highlights only selected provisions of the law. It does not carry the weight of the law. Visit fppc.ca.gov or contact advice@fppc.ca.gov to learn more.
Testing 1 2 3, testing 1 2 3. This is a test of the IT audio system in the hearing room.
we've had the mainline stipulations like this come to us, we've asked, that hopefully you're prepared for, is if you were to take all the violations, and I know in the stipulation it says here's the maximum amount that can happen, it's $106,000, but that's based on the counts that were brought. What were the total number of violations that could have been if you'd thrown everything at them? And maybe it's a range, because sometimes you make things a count and sometimes you make things just additional conduct. And I also am interested in learning what could have been the total maximum that could have been sought in fines.
As with almost every case, there were some filing violations that were not charged specifically as counts. They were noted as aggravation. I don't know if there was how many of those there might have been, but we typically in even the most egregious circumstances, we will not charge every single possible thing that you could find, because a lot of times the conduct overlaps in great detail. And I don't know the exact answer in terms of what filing counts there might not have been, or that we might have been able to charge that we didn't. What we did charge, that is what we would typically do in a case of this nature, or in any case. And the maximum there is outlined in page 33, I think, is $106,000.
Yeah.
And that was based upon the potential trebling of damages on the advertisement count. And we didn't fully treble, we only went 2.5 times on that particular count.
And the reason this question is important to me because of the public comment from someone in that community. And for me to just put this in context is to understand, had all the violations that occurred here been tallied up, what that is. Do you have any sense of what that high range could have been?
I don't, to be honest with you. In terms of the non-charged filing counts, it was never believed that we should go to that length, to be honest with you. We went after the main counts in terms of the money laundering, which are maximum numbers. The filing counts that were on the 24-hour reports, those are charged in addition to pretty high numbers on those, and we went 2.5 times, which is discretionary. I mean, we didn't have to go above the 5,000 necessarily on those, but we went to 2.5 times, so it's a $50,000 number instead of a $5,000 number or something in between. And so we felt that we were in a spot where this is the largest stipulation that we've had since November of 2019 for an administrative matter. So this is a very significant result, and certainly in keeping with, if not higher than what we've typically done in most cases, even money laundering type cases. Excuse me.
It is because it's so large, and I'm sensitive to the public comment that I really was trying to get whatever could have been the higher bound. So thank you. It sounds like you don't have that information. Do you know if this is something that is there any conduct here that could be referred to a prosecutor for criminal prosecution? We have done that in the past. The commission has said not only do we agree with this stipulation, but we direct you to refer this to the DA. Has that been evaluated, and are you aware if that's a possibility here?
Well, it certainly wouldn't be at this point. I don't believe that. I don't think that this matter was referred to the district attorney. I don't know that it would rise to the level of criminal behavior.
I guess my feedback would be if that would be the one stone to make sure is not unturned, that it is, if this is approved today, that in addition, the team look at if referring this, or just refer it to the local district attorney and let them use their discretion and their analysis to see if there are criminal violations here as well.
Okay.
That's my suggestion. Do you, in response to the public comment, do you have any, can you respond to it, please? I think I'll just say it directly.
Well, I think my response would be that, this is, I think, the highest penalty that we've had for, at least in the administrative realm, for these advertisement type cases. Even the Crystal Geyser case that is sort of the precursor, that was not charged at 3 times the amount of the violation there. It was charged at 2.5 or 2, excuse me. This is actually higher than that. I understand the public comment that you want to get the highest number that you possibly can. I can assure you that we spent a great deal of time. This negotiation has occurred over a long period of time in the midst of probable cause proceedings. And we feel confident that this is the right result as opposed to moving forward with a much more uncertain result, which would happen in a lot of different ways. First of all, you don't know what the legal outcome would necessarily be with the trial. There's a lot of additional work that needs to occur for an uncertain result. And also, in a stipulation, you get your money in hand, you get 100% recovery, whereas in a different thing, as you know, like in the default scenario, that leads to more uncertainty on the back end as well. And so here we got what we felt was roughly 85% of our maximum value. And that I think that's a number that enforcement would take in many instances. And certainly that's the decision that we made here.
If I may, I think it's really helpful for the public, not only the individual commenter, but that community that was affected by this conduct and for the rest of the state, that it is a negotiation. That's what I'm hearing you say. And if you don't reach the settlement, if you can go to trial and you may not get as much money or the same kind of finding. And now you can bring this to closure and justice. That's kind of what I'm hearing.
Absolutely. Yeah, these are always negotiations. And of course, you get, there's not a lot of incentive for the other side to settle for a number that is the absolute maximum necessarily of what you could achieve. And, sometimes issues, if you're not in a spot where we feel that the commission would want to approve a stipulation, then we move forward, obviously, in those cases. But in this one, having, a significant settlement, an $87,000 settlement, that appeared to be the correct proposal and the right thing to do to provisionally settle that case and present it to you for decision.
Well, thank you. Those are my questions. I looked at this with one point that is outside the four corners, but in full disclosure. A later matter on our agenda today is a motion to vacate a default, which is about $67,000. And it's for someone who, and we'll go into that in a moment, didn't close their campaign account. And this is gross, intentional, I think basically criminal behavior, even if it's not in some technical way determined later. Terrible conduct that's $87,000. And so when I looked at that, that's why I wanted to go into this much detail, because it is such a egregious case. And later on, we've got something that the person's not accused of any malfeasance or may have even had some other problems. And they're getting hit with something that's not that far off in total numbers. So I look at it that we're not slapping someone on the wrist. And I don't think we are in this case. So I appreciate it. That's just the context I'm looking at this in. Thank you.
You're welcome. Thank you for the comments. And I will just follow up with that and say that, the penalties and defaults are going to be a little bit different than they are in stipulated settlements based upon the cooperation of the individual and the fact that discussion has occurred. And so that's the reason why we try so hard and even go above and beyond in the commission to get people to respond to defaults, is so that they will come respond and we can have a different discussion. But if nobody ever responds, then that leads to a different result. And those fines are higher typically than they are in a stipulation.
Well, thank you. I thank my colleagues and for letting me ask those questions on this one today.
Thank you. All good questions. I think it'd be helpful, as the Commissioner alluded to walk through what the process would be from here. In terms of, an administrative hearing, right? So we talked about a trial, so the next step would be potentially an administrative hearing. Documents would have to be drafted for that. Following that, then the commission would have to meet to consider what the administrative law judge's determination was in that circumstance. And even then, at that point, helpful for us to better understand it and the public, then they can take this out to Superior Court. So if you could more artfully lay that out than I did,
Yeah,
I'd
no,
appreciate that.
You did a good job. I can reiterate that, but I'll take it even farther back. We haven't even received probable cause in this case. We've served a probable cause report, but there has been no finding of probable cause in this particular case. The settlement occurred in the midst of those proceedings where we had properly served the report. We had engaged in discovery, things of that nature. So we would have to finish probable cause proceedings and then go into all the things that Chair Silver mentioned, which is preparing the accusation, assuming that probable cause is found on all of the counts. Then we would get a notice of defense. We would have an administrative hearing, whether it was before the commission or with an ALJ or before an ALJ on his or her own. And then, yes, you go through that process, an evidentiary hearing, which would be very significant in this particular case because of the complexity. And then you get a proposed decision, for instance. That's decided by the commission, whether to adopt it, reject it, remand. And then the respondent would have an opportunity, if they lost, they would be able to file a writ of mandate with the Superior Court, which leads to a brand new level of litigation.
Mr. Chairman.
Commissioner Baker?
I'm sorry,
No. Go
up
ahead.
to the chair. Excuse me, I was just going to close out, but
Go ahead.
I thank you for that. I would say, I don't think I know the chair is not making this argument, and I'm assuming you aren't either, that because there's that much additional work, that's what we do in some of the cases if we need to if that's the path to make sure it's a just, I'm so sorry, everyone, a just outcome. And that's what happens. If it takes more time, then you do it. It hasn't happened in my 4 years in the commission, but the fact that it takes more time and is a lot of effort isn't a reason not to do it. It's weighed in the scales. And I have no reason to believe, there's nothing you've said, and there's nothing in the stipulation, thank you, Commissioner Ortiz, that we would not be able to reach a higher fine and a higher result. It's just there's time that comes with that and a cost to the agency, and we have an opportunity here to get a pretty high result. I just want to underscore that. We should never find it as a disincentive if we really believe a case should get to a higher amount that we can't negotiate, to take it there.
No,
because we
you're
can.
absolutely correct. And in fact, as you recall, just a few meetings ago, we brought a matter before the commission, relating to a hearing that we are scheduled to move forward on. They are all assessed on a case-by-case basis, depending on what's in front of us in terms of a potential settlement and getting that story out there versus what might be gained with going farther. But no, we never make a decision simply because it's going to take a lot more time that we were going to stop.
Commissioner Brandt?
Thank you, Mr. Chairman. So this is my first meeting. I'm just kind of going to give it the way I approach, and it'll lead to some questions. But, I'm coming on to this commission because I want to build the public confidence in the political system, that things are fair political practices. But that really is where my focus, particularly in this time of disinformation. You have people, elected officials saying, well, I've heard people say, and so I appreciate the level of detail in this report saying, and an email was sent on this date saying this, that puts out the facts in purpose. But what I want to ask about is how you would explain, how does this settlement, because I appreciate the questions of Commissioner Baker, how does this settlement further confidence, public confidence, that we are enforcing it? And this is an outlier. We're being hard on this one because this is nuts. And the kind of thing that they did with the social media and all that kind of stuff, it is an outlier. But we want to communicate, and we are enforcing, we're being strong. How would you describe that in public to the public to say, and we're building public confidence here because we've made sure to enforce the law?
Yes, thank you for that. I think that I would say that we've worked very, very hard investigating this matter and prosecuting this matter for a good number of years. We have money laundering, campaign money laundering is hard to prove. We have a maximum number of counts on that. We have really hit the advertisement issue hard in this particular case with the use of the intermediary. And so I think that the public would feel like we moved very hard on this one. I mean, $87,000 penalty is a significant amount of money. That's the yearly salary for a lot of individuals. And this is a lot of money. It's the highest penalty we've had in a stipulation from an administrative matter in more than 5 years here at FPPC.
Thank you.
Great question. One thing that I would note, and this doesn't go so much to the public's impression of our work or this case individually, but it's important to remember that this stipulation is going to follow these respondents for the rest of their career. You put in somebody's name, right, into Google, this stipulation is going to come up. People are going to read about the conduct in this case. That's a huge item to consider here, right? We have a practitioner who's named here. Whenever somebody looks at their name, this document is going to come up, right? I also, I agree with Enforcement Chief Lindsay's point that it's important to note that this is a particularly high fine. However, I still sympathize with the public comment, right? When you see the most egregious types of violations of the act committed, you're going to want to find this person the most possible, right? But again, we go back to the balancing test that Commissioner Baker so eloquently laid out, right? The question is sending a case through all these procedural loops to not secure additional violations, but to secure some additional funds worth using our limited staff resources, right? And that's certainly something that I consider. I think another thing to kind of piggyback on what Commissioner Baker laid out is, to be frank, I disagree with your evaluation of whether this could rise to something that should be prosecuted criminally. I think, like what Commissioner Brandt mentioned, disinformation, misinformation in elections is a priority, as I understand it, for law enforcement. So I would think that these are the sorts of cases that district attorneys, that the Attorney General's office should be looking at and should be considering. And I would assume that this has already been flagged for the county. I know when I was in the enforcement division that these sorts of cases were reviewed by the county. So that's something for the public to consider too. That's the chair's opinion as to what we're talking about here, the aggravating circumstances in terms of criminal liability. But of course, we don't have that sort of jurisdiction, so we can't pursue that. And I feel like the FPPC is doing what it can today to shed light on the conduct here, to keep these individuals accountable, while at the same time maximizing our limited staff resources.
I've probably spoken enough. When you lose your voice, that means you're talking too much. But this is important. I do want to clarify. I would have no problem saying, you know what? I think this should be closer to $100,000 of the 106 because it's that egregious a case. And saying if they don't agree to it, prosecute it and take the time. I don't want to give the impression that I am really putting a lot of weight on the fact that that is the course of action. They could challenge it. And there's nothing in the stipulation that leads me to believe we wouldn't be very successful given how much diligent work has gone forward. That's why I was asking the questions and hoping that there was going to be an answer to how much out of is it $106,000 out of here's the high end range. And I'm sorry that you don't have that available to us. In prior meetings, I think I've asked that be ready for that and have that at your fingertips. So I'm still open to whether or not we adopt this. I am hearing from the chair support for that. But I don't want to give the impression that since we've laid out what a hard road it would be ahead, I would have no problem with us doing that, given what a gross violations these are. And I do really think this should be at least referred to the DA's office.
Mr. Chairman,
Commissioner Brandt?
I want to also kind of clarify, because I think the balancing, it's not so much about whether there's more work to do or those kinds of things. I agree with that. But whether in the end is 13,000 or 18,000 or whatever that may be, the additional money, is that going to be enough? I mean, I go back to what does the public see? And I see this is one of the highest we've had in years. This is serious. And I don't know that the public gets more benefit out of getting them to pay. In other words, they're suffering. They're going to suffer, and they're going to have the things like this is going to be on Google and all those kinds of things. So I think that, having it being one of the highest, because this is so egregious, this is an outlier. I think that's the balance. It's about what does it say to the public? It's not about whether it's going to take more work and those kinds of things, but it's about, I don't know that, my judgment is I don't think it's valuable to the public. Are they going to make a difference? Say, oh, well, they only got 87,000. So that's where I come out, because I think balance is important. But one of the key factors for me is what does it say to the public about the balance that we're making?
Commissioner Wilson?
Yes, kind of related to follow up to Commissioner Brandt's question, and I know you've clarified this, over time. For clarification, this particular $87,000 fine, would that be paid by the actual individual, or would it be paid by the political action? By the campaign committee?
Yeah, it's, the items were paid by the individual.
Right, that's what I assumed, but I just wanted to get that on the record. So thank you.
You're welcome. Thank you.
Great. And just to go again back to the issue of balancing, I think it's important to clarify that at least the point that I'm making is not that it would be hard or difficult.
Yeah.
It's the fact that there's limited attorneys at the FPPC, there's limited attorneys in the state of California who have expertise in this specific area. Administrative hearings related to campaign money laundering can take days, have taken days, take a long time to prepare for, and that entire time, your expert in this specific area is preparing for that matter rather than litigating and investigating other cases of campaign money laundering that could be more timely. So that's where I'm coming from. I feel like with limited resources, we want to maximize those resources. I think it's also worth noting this is a 2018 case, and the public would hope that we are focusing on the cases that are impacting their elections now. And I think that's a clear message that the commission has sent to the enforcement division. And like Commissioner Baker alluded to, I do support approving this stipulation for the reasons I laid out. I'd like to hear from the public if there's any public comment on this. Do we have any public comment in the room? Do we have any public comment online? Okay. Any additional discussion among commissioners? Okay, then I will go ahead and move to approve the stipulation. Ms. Vo?
Commissioner Baker,
Aye.
Commissioner Brandt,
Aye.
Commissioner Ortiz,
Yes.
Commissioner Wilson,
Aye.
Chair Silver.
Aye.
Motion passes.
Okay, since it's right around noon, I think we're going to take a break for, well, let's get through the pre-notice default. It's the last enforcement item, and then we'll take a break for lunch. So we have item number 7. That's not on the consent calendar. That's a pre-notice default. Mr. Lindsay, I know you've done this numerous times, but if you could quickly run through why we do pre-notice defaults, perhaps with the differences between a pre-notice default versus a regular default, for the sake of our new commissioner and the public. And then we'll take public comment, what have you, on that item.
Okay, that sounds good. So for pre-notice default, like we have here on number 7, that means that we have received probable cause finding, and we have served that individual with an accusation pursuant to that probable cause order. The accusation starts the administrative hearing process. The next typical thing that would occur there is if an individual wants a hearing, they would submit a notice of defense within 15 days. In a default scenario, that means that the individual didn't do that. They didn't serve a notice of defense. So under the Administrative Procedure Act, we then have the ability to move forward as a default at that point. There's nothing in our regulations that require us to have a pre-notice of that default. We could just move to default proceedings. But as a means of attempting to get individuals to communicate with us, to therefore us try to get compliance, and perhaps have a different resolution than a default, because we typically do want matters to be heard on their merits as opposed to procedural. We post these as pre-notice defaults. There's nothing to be done today. There's no action to be taken. It's really just a matter of trying to alert one last time, if you will, the respondent to engage with us. And in this particular instance, there has been some communication with this particular individual. So you may or may not see the default decision up next month on this particular matter. If the individual does in fact do what he says that he will, maybe there will be a different scenario, or maybe not. But we try to get communication, and we did receive some in this particular instance.
That's helpful. Any questions from commissioners? Okay, because this is a pre-notice default, we don't have to take any action, but we do have to take public comment. Any public comment on this item? Hearing and seeing none, I'm gonna move that we adjourn for lunch, or for recess. For how long? What do you recommend, Executive Director West? 45 minutes works. Let's do that. Okay, so we will be back in session at 12:50. Welcome back. The commission is back from recess, and we will be taking up item number 8, and that's motion to vacate default decision and order in the matter of Sandy Genus for Coast to Mesa, City Council 2016 et al., FPPC number 181359. We'll welcome our general counsel. I guess we'll just let him stay where he is, and our chief enforcement will come up. Our presentation will be from our general counsel, Dave Bainbridge. Good afternoon, Mr. Bainbridge.
Good afternoon. So we have a motion to vacate. We don't see these all that often. I think the last one was about a year and a half ago. So I'll go over the process a little bit, and for the benefit of Commissioner Brandt, since this is his first meeting. A default decision in order is typically the end of an enforcement matter. It's approved by the commission. The default comes about when a respondent in a case either fails or refuses to participate in the administrative hearing process. They're given the opportunity they receive an accusation, they're personally served with an accusation with the allegations of how they've violated the law, and they have an opportunity to file what's called a notice of defense to request a hearing. When that doesn't happen within the statutorily provided time period, the commission can then approve a default decision, as the commission did earlier today. So this was a default that was approved back in November of 2024. The respondent has the statutory right to file this motion to vacate the default decision for the commission's consideration. The reason I'm talking to you today and not enforcement initially is that we're past the enforcement process at this point. The commission is not considering the merits of the enforcement case. What we're looking at, whether there is good cause for the commission to overturn its prior decision approving the default, to vacate the default, in order that a hearing then take place for the respondent. So that's where we are in the process. As I mentioned, the basis for granting the motion to vacate in this circumstance is good cause. What does that mean? So good cause, and this is a statutory rule, is defined to include, but is not limited to, a failure of the person to receive notice of the accusation, which in this case we have a proof of service, personal service on the respondent, so we don't have that issue here. Her motion did not allege that she didn't receive service of the accusation. The other grounds called out in the statute is mistake, inadvertence, surprise, or excusable neglect. You have presumably read her motion. You've also read the response from enforcement regarding what she claims. In reviewing it, I don't perceive grounds to grant her motion to vacate in this circumstance. I think most of her claims are related to the case itself and why she was not responsive to the case. We're really just looking at whether there are grounds due to failure of service or some sort of confusion regarding the accusation and the default process that would justify overturning your prior decision to allow her to then go back and have a hearing. So that's where we are in the process. The commission has some options. They can grant the motion to vacate, which would mean we would be going back and having a hearing on this matter. Enforcement would probably have to start by serving another accusation. So we'd start over at that place. The commission can deny the motion, or it can take no action. Taking no action has the same effect as denying the motion. So those are your options. If you have any procedural questions, happy to answer them for you.
Before we get into commissioner questions, would you walk us through the notices that were provided to this individual, either generally or specifically? So to give us a level of understanding of what her knowledge was.
On default or the entire enforcement matter?
On the entire enforcement matter.
Okay. And I'm going to talk about a normal enforcement case. I haven't gone through this record thoroughly, but how it would typically happen with enforcement is there would be a probable cause conference noticed, usually by mail that's done. They have an opportunity to request a probable cause hearing.
And sorry to interrupt you. So prior to that piece, this individual as a candidate, as a public official, has already received other notices from their elections officials saying you haven't filed this report.
Yeah, filing officials are required to provide notice to the filer before referring it to the enforcement division. So I would assume that took place.
So
in
there's
the circumstance.
so in general, so that happens, and then we have our enforcement staff are going to reach out to this individual, and then we get to eventually the procedure you talked about, probable cause.
Yeah, and once there's a finding of probable cause, that authorizes the enforcement division to issue an accusation. Accusations are personally served on the respondents. So she was personally served in reviewing the record. There's a proof of service regarding that. After they don't request a hearing through a notice of defense, the next step would be they would be served with the default. This default went on the commission agenda for pre-notice, as was discussed earlier, our process that we've added to get the attention of the respondents and hopefully reach a resolution short of a default. And then it would have been back for default on the November agenda, and that was when the commission approved the proposed default. And then once the default is approved by the commission, the respondent is provided notice of that.
Any indication why the respondent at this point decided to interject, petition the commission versus any other circumstance? Any other, Mr. Bainbridge, Mr. Lindsay, either one of you can chime in.
Yeah, I know nothing other than what's in the papers on the agenda.
Yeah, it's not entirely clear to us either, although there was some media reporting in relation to the default. And it was after that, whether it's coincidental or not, it was after that point that we received the motion.
Okay. To the extent that it's permitted, and I feel like we have, kind of a broad range of facts that we can review here, because this is already an approved default, right? So if you could walk us through some of the individual's background, basically circumstances for why they would be, their level of negligence, I would say, would be lower, right, than someone who had not served in public office. Long story short, to rephrase, can you give us some background on the official?
Yes, she had been a public official for roughly 35 years in various capacities. So she was, presumably very familiar with the items that she needed to file, with respect to her campaigns and her committees. As the motion indicates, we don't have any specific information about it, but taking her at her word, she had some difficulties in and around COVID and didn't stop complying with her filings.
Are there any other facts in the enforcement's response that you think you should highlight for the commissioners?
No, this is, a typical scenario, I guess, where an individual doesn't file the paperwork that they're supposed to file. As Mr. Bainbridge indicated, this really, this is a procedural situation now. I mean, the papers were all submitted to the commission pursuant to the November hearing, and the default was approved at that point in time. With respect to the good cause that she needs to show why she didn't respond to the litigation. And the motion not only doesn't articulate any facts relating to her inability to respond, it affirmatively states that she was back to her normal life by 2022. So again, she was notified of the probable cause proceedings. There was no response. She was personally served with the accusation. There was no response. There was no response to any of the default procedures, and she doesn't appear to be here today. So, I don't think that there's been any showing whatsoever of good cause to grant her motion.
Ms. Vo, is anybody on the line, respondent or otherwise? No? Okay, that's helpful. I'd welcome comment from other commissioners. Any thoughts from commissioners on this? Commissioner Ortiz?
I had questions, but the questions were denied in my brain. General counsel said that we have to focus only on this, not on the case per se, correct? So I pass.
Commissioner Brandt?
So do we give thoughts? I mean, in other words, I kind of have some conclusion. I mean, but I kind of was hoping there'd be more discussion and people would share their perspective. So I'm going to defer to Commissioner Baker to share comments.
Well,
That's up to you in the chair. I'll wait for, I'm just going to wait my turn.
Why
Happy to
don't
hear
we do
yours and the
this?
colleagues.
If
Yeah,
you wouldn't
I do have
mind,
some questions.
Mr. Bainbridge, if you could apply the facts here, what's being put forth by respondent, I don't know what she's officially at this point, and apply that to the standard. So we could have an understanding of that piece. Since this is the first time we've considered a motion to vacate. And this is the first time that Commissioner Brandt has encountered these facts.
Me too.
Right.
Never had.
Well, you were there when we
Oh, when they did
considered
the
the stipulation.
So you're asking about the applying the, okay.
Correct. So essentially the evidence that the respondent has provided, serving as the basis for her claim that good cause has been found and that this should be vacated.
Mr. Chairman, maybe I could help a little bit as the new person.
Of course.
The thing I'm looking for is, so I've read the memo, read the staff memo, but it seemed to be, I'm trying to see the weighing and this kind of stuff, because I don't see something. I mean, if we could do nothing, what's the standard for us actually doing something to turn it around? And kind of, I hear enforcement saying there's no basis here, but can you help me understand how you weigh these things?
I think the way to look at it is in terms of due process and opportunity to be heard, and whether she had a fair opportunity in this circumstance in the default, from the accusation to default portion to participate in the process, which is why one of the grounds is that is good cause is failure to receive service of the accusation. The accusation, similar to a civil complaint, makes the allegations as to what the violations are, and they have to be served with that personally. So that's the first grounds. If someone doesn't receive notice of what they're being accused of, then how would they have an opportunity to defend themselves? And then the second part is more of a catch-all: mistake, inadvertence, surprise, or excusable neglect. To me, that means, is there some other reason that she didn't request a hearing or participate in the process that is explained by what she has included in her motion? And as I said earlier, I don't see anything in her motion that would rise to the level of explaining why she did not in any way participate in the process, that a default was issued against her and she didn't say a word and we didn't hear from her at all. And this is the first we're really hearing from her. So hopefully that encapsulates what your analysis should be in this circumstance.
Thank you. That's helpful.
Commissioner Baker?
So thank you. I also wanted to hear my colleagues' thoughts first, but I have some questions and I'll take a couple steps back for hitting them. One is, when I looked at this, certainly it's a perfectly reasonable memo that has been provided from the staff, and I appreciate that. But as I look at the motion to vacate, just as a human being, sometimes we have folks who've come to this commission and they've just been like, I don't care about the FPPC. I'm going to do my thing. In fact, we've done reconsideration on the eve of default multiple times for people who've come up here at the comment and were not cooperative, cost us a lot of time and money, and we still gave them a second chance. That's happened multiple times, actually, since I've been on the commission, where we said, okay, probably not great, but let's give them one more chance. We want compliance. We want to be compassionate. We want all of it out there. When I look at this, I see someone who has portrayed a story of maybe they might have experienced, as they identified, isolation, possibly depression. They might have other things going on in their life where they're not coping well, and they're just making bad decisions, ignoring the mail. I'm picturing a scenario where I don't have a lot of evidence to base this on, but it's what's been portrayed to me, someone who could use some help getting it together. And for whatever reason, probably because they got served that it's now time to pay money, they're coming to us and saying, hey, I did not have my act together. I'd like to get my act together. I'd like you to reconsider, and how can I make this right? And given how we've kind of showed, I want to say, compassion or some second chance on the eve of default multiple times with folks, I'm kind of inclined to do that, but I'm trying to identify what the option might be. Oh, you have a facial expression. Go ahead. Did you want to?
Oh, no,
chime
I'm
in
sorry.
there?
I thought you were finished.
I'm getting there. Sorry.
Oh, no.
So that's just looking back or taking a step back. That's what I'm seeing here. And I'm going to look I'm trying to find a path that instead of just, okay, we're denying it, is there something else? One of the something else might be more directed at Director West, which is if this default judgment were to remain, is there some feedback the commission can give or some discretion you have for the collections component of this? This is someone in their 70s. We're not talking about the underlying matter was, again, malfeasance, abusing funds. They didn't close their campaign accounts. Serious, but not, as the biggest public harm. Do you have any thoughts on if the default remains, what additional discretion this commission might use, perhaps it's through you, to collect what seems fair and right, given the circumstances?
Oh, I will assist my boss
Sure.
here. So the commission last year, I believe it was, adopted a regulation for the collections process and gives the executive director some limited authority to reduce penalties.
Okay.
The commission can't do anything today that would change other than reverse and vacate the prior default that they have adopted. They can't issue an order today saying, fine this person less money. To the extent that this person's situation falls within the collections authority that the ED has been given to reduce the dollar amount of penalties, that would be a possibility. I'd have to look at that regulation. Typically, it's not immediate. It's after some time when people aren't paying. You look at their ability to pay. It's the general nature of that. So you couldn't give her authority today to say only collect half of this. It has to fall within what's in the regulation for settlements.
Okay. That's helpful for me to see. In addition to you can do nothing, you can reject, you can grant. There's something that's coming after, potentially, based on those regulations, and that's the collections process. We don't know much more in the details, but I'm mindful of that. That may be an opportunity to take into consideration the expression of problems the respondent was mentioning. Maybe the motion isn't it. I wondered, is there any precedent recently where the commission has granted a default, a motion to vacate a default or reversed a default in any other way in the last few years? I know we've dealt with default or have given people a second chance, but once it's granted, can you address that, please?
Sure. One thing I would like to address is that you used the phrase eve of default and things that may have occurred in those situations. And you're right, we have looked at a couple of situations recently. I want to reiterate, though, this isn't the eve of default anymore. This is post-default.
I understand.
A decision has been made. A lot of opportunity was afforded this particular individual to participate and didn't participate. And typically in these situations, it's only for failure of service or extreme medical issue that is verifiable by a doctor that really prevented the individual from participating where good cause is shown. And so that's what was the second part of your question?
Well, the question was, and thank you, I appreciate that, I'm mindful of it, is there can you cite or refer to any precedent in the last few years or ever when the commission has granted a motion to vacate a default?
I can't personally. We've had one motion to vacate a default in my tenure here over the last 18 months. Pretty similar type of scenario where there was, discussion about the violations themselves, but there was no good cause shown as to why there was no participation. I don't know if there's been a prior scenario where the facts were shown in such a way that good cause was established to the commission's satisfaction that a default was overturned.
So just to clarify, so we have not vacated we have not accepted one of these motions to vacate as to a default in the past 18 months.
That is correct. There's been one such motion and it was denied.
Okay, so there's been one such motion and it's been denied. Okay, I just wanted to clarify that one piece.
Thank you.
But go ahead.
I'll try to get through these. As I read this, I also noticed the point was raised. This is someone who's been in office for many, many years. I don't know or recall the circumstances under which they left office or if they'd ever been in a position to have to close an account before, if they'd ever lost or left. That was a little bit relevant to me in the background of all people should be charged with being mindful of what the rules are, whether you're retiring from office or losing. But it's a little more probative to me if they've ever been in a position where they've had to close an account. They actually knew the rules, in addition to maybe they just should have known because they've been in office. Do you happen to recall anything about the circumstances? Did they lose? Have they closed accounts before?
I don't know if they've closed accounts before, but they've redesignated accounts.
Okay.
Or committees. This individual's stopped being a public servant because they lost an election.
Okay, got it. And I guess my final one is what I recall from the underlying facts wasn't malfeasance. You know, the intentional disregard, the kind of conduct that we saw earlier today, for example, that we've prioritized. I tend to be, believe it or not, an occasional softie. And if folks have portrayed a story where you may have been experiencing, I'm not a doctor, depression, you don't have your life together for whatever reason, and you're trying to make right, I like it when we try to find a way to help them make right. I don't think the motion to vacate is a way we can do it based on what I've heard today. If one commissioner can say, I really hope something might be at least looked at for collections to see if there is, within the rules that this commission has adopted, appropriate use of how can we find something that's going to work out for her. I would encourage that, but I'm just mindful that this does seem to be someone who didn't quite have it together, happens with human beings. And if we could work it out, that would be consistent with the second chance we've given to people who call right before default and say, oh my God, I'm finally paying attention and I want to make it right. Those are my thoughts.
All good points. Commissioner Wilson?
Yes, thank you, Chair. And perhaps Mr. Bainbridge can answer this question. We haven't discussed the actual dollar amount that's involved. And I looked at the October and November agendas. Is it appropriate to discuss the actual amount of the penalty, or is that outside of what we can discuss at this point?
It's not relevant at this point. The option is either to grant the motion to vacate, and that completely undoes the default, or to not do it.
The only reason I ask is because the amount may dictate what decisions are made or not made, but I understand the parameters, so thank you.
Along the line with that, if you wanted to know the parameters in the regulation that you passed, 18318 is the regulation for collections. And it says the executive director has determined the settlement is appropriate for a reduced amount following factors. The settlement amount exceeds the amount likely to be collected within a reasonable amount of time. The debtor's ability to satisfy the full debt or greater amount of debt within a reasonable time given the debtor's assets or income, or the debtor's reasonable prospects of acquiring assets or income. The extent to which the debt owed includes interest accrued with the original penalty amount and the severity and type of violation for which the penalties were assessed. Those are the criteria that have to apply.
And then I'm going to go to Commissioner Ortiz in one moment. I think basically what Commissioner Baker laid out there, where we would give the respondent an avenue to advocate within these criteria, I think is a good alternative, right? This is why we adopted this regulation. We could encourage this individual, which it is notable that they are not here today. They had the opportunity to call in, they had the opportunity to come in person. They opted not to, just like they opted not to respond to prior notices that were provided by elections officials, enforcement division, and ultimately, again, from the commission for this. So
And I would
it'd be worth our time to let this person know that they have this avenue and that we encourage them, if they think it's appropriate, to pursue it.
And part of the regulation the commission approved is that we do make reasonable attempts. There's a certain number in the regulation that I have to go through before I can even talk to them about any reduction. So we do have to attempt to collect the debt.
Commissioner Ortiz, thank you for being so patient.
Thank you, thank you. I don't know if you explained it, but I'm going to ask it again. If the commission were to grant the request to vacate, then what happens?
Then there could be a hearing. So we would go
So-
back to,
A hearing not from the commission, but somebody else?
Well, the commission could hear it, or it could be before an administrative law judge, just like any other administrative hearing. We'd basically start over at the process of sending out the accusation. She would again have an opportunity to file a notice of defense, which would permit her to have a hearing on the charge.
So that administrative hearing, what will be the goal for that? If they hear the whole thing, what will be one of the outcomes, that the fine will be reduced, or what?
It would be as if this never happened. So it would just be,
Start ground zero again?
right.
But all these facts will not be dealt with again? Or
No,
what?
they would be. So all the
On the
facts
on the
that are alleged.
administration hearing level,
Right.
not on the commission level?
It would eventually, assuming it goes to a hearing, it would eventually come to the commission for final approval.
Okay, so at that point, that's when maybe fines can be dealt with and, whatever. Yeah, okay, thank you.
Commissioner Baker?
Thank you. I appreciate the good question of Commissioner Ortiz. If it starts over, would a stipulated settlement also be possible? Where she says, okay, I can't do that. You start that over. It's not immediately to hearing. It's that whole process as well, or is that not correct?
No, that's correct.
Okay. And she'd obviously have to close the accounts, which is the.
And file all the statements that are missing and come into compliance.
Yeah. Okay. Remember, I'm a big softie, so.
And another thing to consider here is, in contrast to other stipulations, right, that we generally deal with, we can't come together as a commission and decide right now that we feel like the appropriate fine here would be 20,000, and then move to adopt that penalty amount in place of the penalty that we ultimately approved last meeting. That's correct, right?
That's right. I mean, you could give guidance, but that doesn't mean that this person who hasn't participated in the process throughout would then agree to settle for that amount.
Okay. Any other comments from commissioners? Do we have any public comment? Okay. Commissioner Baker?
Perhaps you were going to do this, but I welcome your thoughts. If you're, it sounds like perhaps you're are leaning towards not granting the motion. I might be leaning towards if we granted it and with whatever guidance, that, hey, give her a chance. If by a date certain doesn't reply, this goes back to default. We start the default process over, pre-notice default. That's kind of what I'm seeing as an alternative, or the collections discretion. But it sounds like there's some steps that have to be taken before you even get to do that. So I guess I'm
Sure.
inviting your good input.
I appreciate that. So I think my perspective here is coming from my experience as a filing officer myself for the state assembly, right? And then as a prosecutor for the enforcement division. And from working with all the different electeds that I've worked with, staff, et cetera, I just can't imagine a situation where a public official would receive all of these notices and then in good faith not respond to any of them, regardless of the situation. As you know, the assembly members, assembly staff, they're human beings. They go through all sorts of trials and tribulations, and I'm unaware of any sort of situation like this that's ever come up. I think this is just particularly egregious. I think you get notice after notice after notice from the county, and then from enforcement, from the intake person, right? And then you have the investigator reach out, and then you have the attorney reach out, and all these different people are providing notice. And one fact from the actual motion itself that was worth highlighting was that notice was thrown away by the individual, right? This person who served in public office for 30 some odd years threw away notice from the enforcement division of the state, right? And when you enter into public office, you're entering into a public trust with the people of California. And it's not to be taken lightly. And that's why we have these rules, right? It's a reason why a lot of people don't want to go into public office, frankly, right? Because they're worried that something like this could happen and then they'd get penalized for it. And I feel like this person availed themselves of these sorts of laws for years and years, decades and decades, and opted to ignore correspondence from law enforcement. And I think if a general, regular, member of the public heard that after someone ignored law enforcement year after year after year, county resources were wasted, state resources were wasted, and then we spent more resources on this, I think they would be disappointed. But that's my opinion. That's why I would move to support this. I have the same reservations you do, just in terms of the impact that this sort of penalty could have on somebody's life. And that's why I would strongly encourage them to participate in this process, right? To call in during public comment or appear in public comment, to reach out to the executive director and cite the reasons that they're going to have trouble paying this fine. So that's just my personal opinion from my experience as a filing official. Commissioner Ortiz?
Thank you. I appreciate Commissioner Baker's desire to be compassionate. That's a good heart. So rare to see. But I agree with the chair's analysis. This was egregious. I mean, there was just, FPPC went out of the way many, many, many times. And then at the last moment, she finds, oh my God, I better do this. I agree with your analysis.
Commissioner Wilson?
Yeah, and just for the record, if anyone hasn't gone back and looked at the prior information, how many years are we talking about that the FPPC was involved with this case?
Since 2018,
Right.
we've had a year's worth of, attempts at communication.
So, okay, so we're talking like at least 5 to 6 years.
Yes.
Okay, thank you.
And then one additional agency that I didn't mention, so Secretary of State, would they have sent this person notices as well? Because there's annual fees that have to be paid for committees.
Likely.
So in general, my understanding is you're gonna have county, you're gonna have FPPC, you're gonna have FPPC enforcement specifically, California Secretary of State's office, all these people are reaching out, all these different agencies are reaching out to this person. And it was over the period of, I don't wanna get this number wrong, but several years. So just another agency that provided notice worth noting. Any other comments from commissioners? So I am going to move to deny the motion to vacate. Do I have a second?
Second.
Ms. Vo?
Commissioner Baker,
Aye.
Commissioner Brandt,
Aye.
Commissioner Ortiz.
Yes.
Commissioner Wilson,
Aye.
Chair Silver,
Aye.
motion denied.
Thank you, as always.
Thank you.
Can I want to clarify real quick. The motion was approved to deny.
Yeah, sorry. Should we, let's,
No, that's fine. I think the record's clear now that that's.
thank you, Mr. Lindsay. Thank you, Mr. Bainbridge. So let's move on to item number 9, and that's going to be a pre-notice discussion of proposed repeal and amendments of regulations concerning electronic filing of statements of economic interest with the FPPC. And up at the table, we have Valerie Nutting, Commission Counsel. Good afternoon.
Good afternoon. Oh, yeah, it is afternoon now. Good afternoon, Chair and Commissioners. As the Chair introduced, my name is Valerie Newting. I'm legal counsel with the Legal Division, and I'm presenting to you today for pre-notice discussion a set of regulatory amendments intended to update regulations pursuant to amendments to the Act made under AB 1170, which was a Commission-sponsored bill. To give some overview of what statements of economic interest are and how we've dealt with them in the past, I'm going to just give a little bit of brief history. So the Act requires elected officers and public officials, including state and local government employees, who make or participate in making governmental decisions, to file statements of economic interest, otherwise known as SEIs. These statements disclose relevant financial interests that might impact their decision-making. SEIs are filed annually, as well as when assuming and leaving office, and promote transparency in government by providing necessary information to the public about an official's financial interests to ensure that officials are making decisions in the best interest of the public and not personally benefiting from the decisions. Now, up until about a decade ago, SEIs were filed on paper, but in 2013, AB 409 passed, and that permitted the FPPC to develop an online system for SEIs to be filed electronically. And they began accepting SEIs through that system in 2016. At that time, it was not a requirement for the statements to be filed electronically, so some still did file on paper. To provide some perspective of what that looked like with some on paper, some online with us, some online with others, in 2024, 25,458 SEIs were filed with the FPPC. Of those, 20,090 were filed electronically, and breaking down that number further, 13,633 were filed directly with the FPPC using our online system, and 6,457 were filed through an agency's electronic system, who then did a data transfer to the FPPC, and we would have to make sure all of the information was in the right place and all of that good stuff. So as you can imagine, this resulted in hundreds of staff hours fixing issues with the data transfer and also scanning any filings that still came in as paper, which is why the FPPC sponsored AB 1170 to eliminate the burden on staff and the waste of public resources, and also to increase transparency and efficiency. Now we can get a lot of these statements in one place. After the passage of AB 1170, public officials who are required to file statements of economic interest with the FPPC must now file them directly with the Commission using the FPPC's online filing system. This will promote efficiency and eliminate the hours spent by staff fixing those issues. Of note is that in the legislature's analysis of the bill, that was their key interest too, was promoting efficiency and transparency and kind of taking that load off of FPP staff. AB 1170 also made some smaller changes that you'll see reflected in these regulations, such as including email addresses as information that must be redacted when posting information online. We already had a list that included telephone numbers, home addresses, that kind of thing. Email addresses now added. And they also laid out when the FPPC may use discretion to determine whether certain sensitive data can be redacted as well. As you've all seen, I'm sure there's a long list of regulations that were impacted by this. I'm not going to bore the Commission and go through every single one. So most of the changes are really technical, and they're just there to update the regulations to reflect current law. But I am going to open the floor now to any questions to the specific amendments to the regulations that have been presented to you.
That's very helpful. Thanks for walking us through that. Any questions from commissioners? So I think would be helpful, or Commissioner Ortiz, I'll let you.
Are we gonna ask questions about the proposed thing?
The options for what to
Yeah, the
post,
three options that you were talking about.
Yes, we
correct?
can-
Yeah, I have questions about that. The number 2, main goal is to find whether it's available online, including blah, blah, blah. Is that gonna require a lot of extra work, number 2?
So just looking at those, just to make sure everyone's on the same page.
Sorry to interrupt you.
Yes.
You take a step back and
Yeah.
just identify what the decision point is for the commission right now.
That's-
And then what our options are.
I agree. So the decision point that,
Ultimately what we're getting to.
yes,
Yeah, go
the decision point that Commissioner Ortiz brought up is that under Regulation 18313.5, only currently, as it stands, only SEIs of elected officers required to file with the Commission and the chair and commissioners are posted to the website, our website. During an IP meeting we had surrounding these regulations, the issue came up whether the Commission would be open to expanding what SEIs are posted on the website. And so staff and administration, we all worked together to kind of come up with what was some feasible options that could be done within technological constraints that we have, and we came up with 3 different categories of disclosure of posting that we could do. First is we could leave it as is. That's number 1. So that would be just elected officers who file with the FPPC, and then the FPPC chair and commissioners. The second option was that we could post all Section 87-200 filers. So those are the filers who are at a higher level of state and local officials, and they're required to disclose all financial interests. And that, when you see the public comments, that appears to be a popular option among the public comments. And the third would be that we could post all statements that are filed with the FPPC. So that includes even at the employee level. So we have lots of state employees who file with the FPPC, myself included, and those would be included along with the elected officers, the FPPC chair and commissions, and 87-200 filers. Everyone who files with us would be posted. So those are the 3 options that could be done with relative ease to what you were asking, because they're easily identifiable categories. If we wanted to break it down further, for example, only supervisors who are employees with the state, or only attorneys who are at the state, that becomes a little bit more difficult.
So number 2 and number 3, or number 3 will not increase the amount of time that staff will have to spend doing this?
I would imagine that we would have to adjust maybe in the initial stage of, okay, now we're adding these to our policy and how we post. But my understanding was those were options that were identified as is not particularly difficult to post.
Yeah, we've heard from admin that it wouldn't be any extra work for the IT people.
That's important to know. And then I have another question. Why legislative staff raise concern about this?
By their code, they are, correct me if I'm wrong, they're included with the 87-200 filers.
This is something we've
It's
heard
complicated.
from the legislative staff over
Yeah.
time. We've been trying to get this legislation passed for a number of years, and they haven't said it this time around. Maybe it's no longer a
But did
large
they
concern.
say why they were concerned about?
I think just having their information. The sense was having their information available online as opposed to someone having to email us and request a copy of the form. All of this is public
Yeah.
documents. It's just how easily accessible it is really what we're looking at here.
And I apologize, I think I misheard the question. So thank you, Dave, for
Okay,
popping in there.
thank you.
Sure, and then just clarification, so we have the 3 options. We have leave it as is, which is electeds and FPPC commissioners, right? Then we have posting 87-200 filers that file with us, which is all 87-200 filers now, correct?
Correct.
Yeah, okay. And then you mentioned that employees, 87-300 filers who file with the FPPC would then be posted as well.
Right.
So my thought
So
there, I was
everyone.
surprised to hear that admin said that wouldn't take any extra time, because not all 87-300 filers, employees, are required to file electronically with us, right? So there'd be requirement that they scan the hard copies of those other employees and then upload them onto our website. So, and I can't speak for the legislative employees, but if I was a legislative employee, my question would be, why am I being singled out to be posted on, why as a scheduler for a legislator being singled out to be posted on this website when no other employee outside of a very small exception, and I don't know if those people would be upset as well. Why are we being, our financial interests being displayed in this manner versus the other individuals? And the other group, right, is what employees of joint powers agencies. It sounds like there's a very small number of them. I don't know if they have an association and they're concerned about, or they're asking, why are we posting their Form 700s online, but not posting the employees of currently the FPPC? Or that's a bad example because they're going to have to file electronically, I assume. Is that right? So another state agency that's not required to file, 87-300 filers are not required to file with us.
So just a point of correction, everyone who will be filing their original SEI with the FPPC will be filing electronically beginning
Correct.
this year.
Okay.
And that's why it makes it easier for staff, because it's all going to be right there. So it's a matter of just which ones we select to post or not. And so
So then which 87-300 filers are we talking about being posted online?
anyone who files with the FPPC, so for number 3, anyone who files an SEI with the FPPC would be posted online. That's option number 3.
And, do we
And
know
anyone who
generally
is
that-
required to file with the FPPC now has to do it online. So that kind of all comes in together. So all of them who file with the FPPC.
And what groups are those? So it's legislative employees and
There's a lot.
State aid.
A lot of state agency officials file with us directly that are 87-300 filers. People on the UC Regents board are, I believe, are code filers who file with us, because agencies can designate in their code that certain 87-300 filers file with the FPPC, and the FPPC is their filing officer. So if we're designated as their filing officer, they file their original with us. All of those people have to file electronically now.
okay, so like the attorney one with the UC Regents office files electronically with the FPPC?
I
versus
don't believe they
like an
designate
appointed?
positions like that as filing with the FPPC. It's usually the much higher level positions. I see Commissioner Baker leaning in with maybe some information here.
I have to file in Form 700 as a director of a UC facility. And I don't know all the rules at UC, but it goes to folks. And there's a decision making, which is, do you control how this government funded resource is going to be used? And so yes, I think I'm abbreviating it, but yeah.
And
Ortiz?
local agencies, not state agency, local agencies have their own filer officer. And they're not only the elected officials file with the FPPC, I think we file through the filer officer too. And a lot of employees high up also file with the board secretary, who's the one. Do those people have to now file electronically?
Okay, so local systems do have their own process of collecting and potentially posting SEIs. For the local officials who still only have to file their reports with that local agency, so the city clerk, for example, that's not going to change. They will file with the city clerk. However, if there was an 87-200 filer that was filing with the city clerk who was then sending us the information, that's that kind of middle ground that's being cut out. They have to file directly with the FPPC.
Electronically,
Correct.
okay.
Now, what local governments decide to do from there, if for some reason they really want it posted with them too, and they want to require a second filing, that's up to them. However, we are working with admin division to try to get data transfer to go the other way too, to help with that.
Okay.
Great, Commissioner Wilson?
Okay, thank you, Chair. I have one question as a follow-up to what the Chair had referenced as regard, he used schedulers in the legislature as an example. They don't supervise anyone, and perhaps one of the things we can look at is whether it's the legislature or whether it's another entity, governmental entity, does that person have a supervisorial role? Because if you're, for example, an entry-level legislative aide working in a first-term member's office, and you don't supervise anyone, that's different from, let's say, someone who manages 50 employees or even the chief of staff to an elected official. So I think that should be taken into consideration as well.
And that is where, when we discuss option number 3, the challenge would lie in, that would be a difficult technological task to do, to divide people by their by these people are supervisors and these people aren't. It would have to be under that number 3. It would have to be everyone who files with the FPPC. So, I mean, that kind of is part of the consideration for sure, but it's not an option at this point to be breaking it down by position.
And I would just add for the legislature specifically, they are permitted by law to designate in their code where they file. So they have chosen through their code to have the legislative employees all file directly with the FPPC. So that's a decision often made for employees at the code reviewing level by the agency that produces their code. I haven't researched this, you guys are the experts. What if you are, for example,
a supervisor for a constitutional officer, would you, or even a scheduler for a constitutional officer, what category would you fall in that case?
You said chief of staff or?
Any
A
schedule.
What was
scheduler,
the first one? No.
scheduler or a supervisor?
A supervisor may be designated if they have the ability to make decisions that could impact one of their financial interests. They should be included in the agency code. Typically, that sort of position would be designated in the code as filing with the agency, not with us. A scheduler, I doubt, would have the ability to make decisions that would influence one of their financial interests, so they would not be included in the code at all. They wouldn't file an SEI. If the agency determines they would have that sort of authority, then they should be designated in the code and be required to file an SEI. Typically, again, it would be with the agency since they're an 87-300 filer.
All right, thank you.
And they would file with their agency, not us.
Correct.
Okay. And then it would, I guess, be up to their agency whether to post their Form 700 online.
Right.
Correct?
Correct.
Okay. So I guess the question that I'm looking for an answer to, and this is pre-notice, it's something we can develop, build a consensus on, get feedback from staff, is why are we making a distinction between the 87-300 filers that are filing with us directly versus other 87-300 filers? I just want to avoid the appearance of this being an arbitrary decision. And one thing to consider here is, at the end of the day, this information is incredibly easy to access because of the excellent work of our staff in the SEI unit, right? If someone wants to get my Form 700, which is posted online, so that wouldn't be an issue for them, but if they wanted to get your
Mine.
Form 700, right? All they would do is have to email form700@fppc.ca.gov.
Yeah,
They
right.
would receive the request to be received, they would be sent a PDF of that Form 700. There's a reason why certain, electeds, for example, we adopted via regulation that they be posted online because it does cut the middleman out of that process. But for me, if we're going to reduce the privacy of a certain class of public employees, I think we need a good reason to do that. So I think that's something to consider. I support the public comment that 87-200 filers, so individuals who who control public investment, and then specific enumerated elected positions and appointed positions, that their Form 700s be posted online. I completely agree with the public comment. I'm unaware of any public comment that's pushing for this small segment of 87-300 filers to be posted on our website, whereas, and correct me if I'm wrong, the vast majority of 87-300 filers would not be posted on our website. The vast, vast majority in the state of California.
Well, that's correct because we don't have the statements.
We don't, right, we only have the statements that we have.
Exactly. Okay. Commissioner Baker?
Thank you. All good points from my colleagues. I'm grateful for them, and recognizing this is pre-notice. I will be gone when it comes up for the full shebang. Just offer this. There's a world of schedulers out there that are all saying they have a significant role. I mean, it's often that folks in their offices say, you're one of the most important people because you control access. And I don't have a concern about their having to file electronically, that it's not something anybody has to get a PDF. The more that is online in one place is easier for the public. And it's valuable information, what gifts folks have been getting, travel, other things that are on those reports. And so I think the distinction between, it's very good to be considering supervisorial role. I think that's very important because that's a lot of control over resources and people and what they do. But I am for as much disclosure as possible from as many. Make it simple in one place for the public. And I was pleased to hear you're working on a way to have reverse data transfer. If local governments decide they want to put a link to our site and say, here's where you can find so-and-sos.
Right.
Smart minds here are working on it, and I know you'll look into that. But for staff, I think they're in a position of trust, even if they don't supervise folks. They have the ear of decision makers. They're in a close relationship and setting, and I think it's appropriate to have that online. Those are my just general thoughts, but I know this team will figure it out.
And I think just on that very briefly, I think that's kind of the crux of it for sure. And yes, we can't mandate that all of these filers get posted, but we do get a significant number of filings, and we can choose how much we want to make available to the public, and that's what we're here to do. So
Excellent. Well, that's helpful. And to make you feel better, so schedulers, to my knowledge, unless they've changed the conflict of interest code, they are included
Yes.
in the conflict of interest code for
They
the assembly
should.
for the exact
They
reason.
should, they
you
should, they
mentioned.
open that door.
I think the supervisorial is very important to look at, as Commissioner Wilson points out, but also even regardless of that, the access they have to government and the public trust for whatever resources they have available to them. I think it's good to have it all disclosed.
I 100% agree. And I think that what's great about this step that the commission took, that you all started before I came on as chair, was that now we're going to have the most powerful people in California, their Form 700s, all in one place where the public can go review their financial statements, their Form 700 statements of economic interests. As we start to explore disclosing individuals with lesser, still significant influence on governmental decisions, for me specifically, I just want to make sure that we're not arbitrarily choosing winners and losers in this area. Any other comments from commissioners? Any public comment? Go ahead. Good afternoon. Good afternoon. You can go ahead. We can. Thank you for calling in. Sorry, Mr. Canning, you cut out about a minute back. No problem. Yes, we can. Go ahead. Excellent, thank you. And I think it's worth recognizing the excellent work that SF Ethics has done in terms of transparency technology, and you have done a great job there, and you've been a leader for a long time now. We appreciate you providing us with this feedback and for engaging with us. So thank you for doing that. We're more than welcome to consider any, or more than happy, I should say, to consider any proposals that you set forth. But as you alluded to, it sounds like for what your agency is proposing, we need a legislative solution. So for any legislative related items, I'd recommend reaching out to our excellent legislative director, Lindsay Nakano. Additionally, I don't know if Mr. Canning's still there. Mr. Canning, you mentioned you'd recommend disclosure of all entities filing with the FPPC. Does your agency disclose 87,300 filers? You could just email us back off once the commission meeting's over. Okay. Now I'll be respectful of everybody's time. Do we have any additional public comment? No. Okay. Well, this is pre-notice, so we can move on to the next item unless commissioners have any.
Can I ask though, real quick? So far, I hear one vote for 87,200 only. I hear one vote that won't be here next month for everybody. So I don't know if other commissioners have a position at this point. If not, that's fine. We can come back with
Which one
multiple
is
options.
you pushing for? Which one?
Sure. So I actually have an open mind at this point.
Okay.
If we can come up with a good reason for why we want to distinguish between a scheduler for a assembly member versus a scheduler for the state treasurer, then I am open to posting everybody's Form 700 online. I just want to have, that reasoning, some sort of rationale, which is similar.
Got the number 3
That would be number 3, I believe. Basically posting
everybody.
everything that's filed with
for the
us,
sake of transparency and
Right.
information.
including FPPC employees.
Yeah.
Yeah.
Fine. Yeah.
Is that you're leaning? Okay.
Commissioner Wilson.
And I was going to wait till next month to kind of raise this point, but I think it's important to take into account that the overwhelming majority of schedulers in the legislature are women. Not that that should be a decisive factor, but in terms of security, people accessing information, and I realize there will be redacted information, but if I have your name and I have the city you live in, I can probably find your cell phone number as well. Not that I would do that, but that information is available. So
And
something to take into account, I think.
absolutely. And just something on that very briefly, as Mr. Bainbridge mentioned, these are all public records, fairly easy to receive by request already. So I do want to keep that in mind, but I understand that that's an extra step.
Yeah, I mean, it's. I think it's one thing for me to send you an email asking for
Absolutely.
information. There's a
quick Google.
a track record of that as opposed to me going online and searching for information about somebody. So,
Understood,
but I
yes.
appreciate your
Yeah.
excellent presentation.
Thank you, Commissioner. And our IT folks could probably speak to this a lot better than I could. Maybe we'll consult with them before next meeting. But another significant difference is if you're having a bot or some sort of program, just even ChatGPT, right? A large language model, sift through everything on the internet to scrape all that data and collect it and consider it in conducting a search, maybe a search for someone's home address, that sort of thing. That information would not get caught up in a Form 700 that is provided in response to a request for an email. At least not as to any LLM I'm aware of is going to go ahead and request
Put it in.
a copy of that, right? So, I mean, there's legitimate concerns in terms of privacy. The commission did an excellent job carving out areas where redactions can be provided, where someone goes through the process. The reality is, some people, there's going to be a circumstance where someone is not familiar with that exception, et cetera, et cetera. Somebody's address is going to get out there. I can tell you in my previous work at the FPPC, at the Assembly, I had all sorts of people just yell at me, tell me horrible things that they were going to, God knows what they were going to do to me and my family, right? And I think 999 of them are not going to do anything, but it's that one person who goes and follows a scheduler home from work because they're upset that they didn't get whatever service they thought they deserved. So it's just something to consider, and I'm glad you brought it up.
Thank you.
Commissioner Brandt?
So I'll respond to your question. Just I'm going to make a judgment next month. I appreciate the debate and I appreciate Chairman Silver's comments and questions about that. And I think his last comment about its privacy of particularly lower level employees who have to file, that is one of my concerns. I've seen too many, and when people run for office, they buy into a certain level. But someone who's just trying to do things that are at a lower level, they don't buy into that. So that's why I have concerns about privacy, but I have concerns about transparency. I want both, but that's why I look forward to hearing what staff has to say in balancing those two interests and kind of whether it's 87-200 only, that may make sense. But I need to hear more analysis. That's where I am.
Okay, we'll
Sounds to
bring
me
back
like the
two
consensus
options.
is either all 87-200 filers,
Or-
right, are going to be posted on our website, or everybody who files with their agency. I don't think there's support for keeping the policy as is. We're just electeds and
Excellent.
commissioners. So I think if we could get those two options before the commission when it comes back for consideration of adoption, and then if we could speak to what the rationale for making a distinction on 87-300 filers.
That file with us, correct?
Yeah.
Okay. Thank you so much.
Okay. Let's move on. My microphone on. Let's move on to item number 10, and that's adoption of proposed revised expenditure codes. And we're going to have a presentation from a manager of Education External Affairs Unit in the Legal Division. That's Chloe Hackard. Good afternoon.
Good afternoon, Chair and Commissioners. As Adam said, or Chair Silver, sorry, I've known him a long time now. I am the Education External Affairs Unit Manager in the Legal Division. Today, for your approval, are updates to the expenditure codes for reporting campaign activity by committees that will take effect upon the certification of the Secretary of State's new online campaign filing system. Expenditure codes are used to describe the payment of campaign expenditures by committees. Proposed changes are recommended for approval now to implement into the new Secretary of State Cal Access Replacement System, their new online filing system, while it is currently being built. The FEPC partnered with the Secretary of State's office to update the expenditure codes and instructions to reflect current campaign expenditure practices and terminology reported by filers. These up-to-date expenditure codes and descriptions will lead to more consistent reporting practices amongst filers and committee treasurers. Additionally, the draft expenditure codes and instructions were made available on the FEPC's website for public comment and review in December and January. We've received public comment from the regulated community and made responsive edits, which are the green highlights, in response to those comments. We really appreciate the feedback and suggested edits from the public and regulated community, as they frequently work with these expenditure codes as professional treasurers, compliance firms, and advising committees, and may have a different perspective than us here at the Commission. We initially noticed the updated expenditure codes as a part of an updated Form 460 Recipient Committee Campaign Statement. Upon further review and testing of the current Secretary of State online campaign filing system, Cal Access, it was determined that these updates could not be implemented due to technical limitations in the current SOS system. Therefore, these updates are presented independently as is to be implemented into Secretary of State's new online campaign filing system, CARS, to take effect upon its certification. Since noticing the updated expenditure codes, I wanted to highlight some of the changes we have made in response to public comment. Those changes are again highlighted in green on the form. We added the expenditure code postage back as a code per the request of the California Political Treasurers Association. They explained that this is a commonly used expenditure code by them for their committees and their filers. This is something that they often report for sub-vendors, so they asked to have that be put back in since it's a common code that they will be using a lot when disclosing campaign activity for their clients. Additionally, we added a new expenditure code, which is PPF, and that stands for Payment Processing Fees. This was at the request of Rebecca Olson. We have seen that electronic contributions are becoming increasingly popular. and amongst committees and candidates. So the individual processing fees for those electronic contributions would be coded as an expenditure, and it'd be a lot easier for these types of committees to report those expenses with this expenditure code. Additionally, we removed nonpartisan before voter registration with public comment from the Assembly Elections Committee. Since multiple types of committees will be using these expenditure codes, we want them to be as universal as possible. Additionally, we added cable and clarified TV ads at the direction of commission staff. And one thing I would like your approval on is I'd like to remove postage from office expenses. So if you can approve that with me today, we noticed that that was also there when we put the postage as its own code back in. So today we recommend your approval of the revised and updated expenditure codes at the request of Secretary of State. The Commission is required to approve forms for reports and statements. Since these expenditure codes will be part of an updated form later, as Secretary of State's new online filing system is closer to launching, we are presenting them to you now to ensure that the Commission is on board with these changes and so that the Secretary of State can implement them into their new system as it's currently being built right now. Again, once approved, these updated expenditure codes will be implemented into the new CARS online filing system and take effect upon their certification, which at this time is slated for currently the end of 2026. And that is my presentation.
Excellent. Thank you. Great presentation. Great work on this. I can tell you that I reached out to California Political Attorneys Association, California Political Treasurers Association, and both of them complimented you on being inclusive in this whole process and taking their feedback into account. So I really appreciate you doing that. They're the ones who are looking at these quite a bit every election season, so they have a really good eye for identifying issues. And I appreciate you doing that outreach. So we're switching payment processing fees to PPF. What were they expenditure coded before? What was the code for them before?
Well, this is in our effort to modernize. So in the codes before, I think that you would often see them probably being used under campaign or fundraising. There wasn't a specific code for this type of activity, so now there is. And sometimes, again, sometimes it's a transactional fee of 3% of your contribution, but that adds up if you have hundreds of thousands of contributions. And so it's a lot easier for them to code. And in discussions with CPTA and CPAA, we can find that they do a lot of organization before the filing. So they use this as part of their tracking for expenditures in advance before the filing deadline. So it's helpful to have these codes early that they can kind of prepare for that when it comes to filing periods.
Excellent. Any other questions from commissioners or comments? Yeah. Commissioner Ortiz?
Thank you. As a former elected official, I really appreciate your doing this because there were times when it was just so confusing, like you just described, individual things. Are we adding, the Secretary said, are we adding a new page, sub-vendor page?
These codes will be used for sub-vendor payments as well, so they'll be universal for expenditures. But what's happening now is that Secretary of State's building their new online filing system. So these are being approved for a delayed implementation when CARS goes live. These will not be in effect right now on the 460, just because Secretary of State's current system does not have the technical ability to add any changes in. So the Secretary of State's office has requested that we get these approved with commission input and feedback now so they can put them into their system as it's being built with the developers right now, set to launch at a later date once approved.
I think that's an important one because when you declare a payment through credit card, then you have to figure out where is the sub-vendor, and it's kind of confusing. But I'm glad you're doing this because I always thought it was
we're hoping that the new online filing system will make it easier for folks too on informing them about those types of requirements and additional disclosures.
And I don't want to sound too complimentary, but again, just want to flag that you and Executive Director West has been working closely with SOS to make sure that this rollout of CARS is effective. I've seen lots of different transitions in government where these sorts of not necessarily major changes are considered ahead of time. And because they're not considered ahead of time, there's issues almost immediately, and it makes everybody look bad. So I just want to compliment both of you on being so far ahead of this and really making the regulated community's life easier and SOS's life easier as well. So thank you for that. Any other comments, questions from commissioners? Commissioner Brandt?
So my question is actually follows up kind of in some ways on his, but I was going to ask it anyway. And that is, I want to understand the relationship. When you say partner with the Secretary of State's office, what does that actually really look like? I mean, is that IT staff and IT staff talking to each other and compliance? You know, I want to understand because in some ways, you know, she's an elected official as well. So, and I've been part of the CARS delay. I've been part of the discussions of how long it's been taking to get the new system up and the rejection of the temporary proposed system. So I want to understand partnership. What do you mean by that? And how does that actually work? As opposed to, I think, going on and getting comments from the Political Attorneys Association, that kind of thing. What's partnership mean between
Do you want me to
FPPC
go,
and
or do you want to take it?
Secretary of State?
Sure. Galena West, Executive Director. So partnership in terms of CARS and partnership in terms of our daily lives are a little bit different. So in our daily lives, Chloe and her team, Ms. Ackert and her team, they work closely with Secretary of State's office because a lot of the same people asking Secretary of State a question is the same people calling us for questions, or we get their questions, they get our questions. And so there's a lot of collaboration. Ms. Ackert and I have a meeting with Secretary of State's Political Reform Division staff every 2 weeks to go over any issues. And so that's the general communication between the two agencies that we keep constant communication. And I'm sure you guys communicate many times in between those meetings as well. And so then when things are identified as a need for CARS, I attend all the CARS meetings, external stakeholder, internal stakeholder, executive meetings, to stay apprised of the CARS progress, and we get to see the wireframes. We participate in the third-party vendor meetings, and we also are doing our own internal work for CARS, where we're trying to propose what we see the fields going to be as we move forward with because there's a whole section in the Act that has information about any legislation that has gone into effect that has been passed that will go into effect after the certification of the system. So making sure that all of those coordinate with the existing provisions of the Act. So it's a very fluid relationship. We constantly meet, we constantly interact. We just set up an additional meeting where we can go over the different fields and making sure the system will not be form-based as opposed to data-driven, and that it'll meet everybody's needs. And then I say the final thing that we're in constant communication about is making sure that we can enforce all of the things that are filed through that system as opposed to how they are currently filed. Making sure that there's certification, there's still penalty of perjury, there's still all the things attached that we need, the date-specific information. Do you want to add anything?
Yes, I'm going to also give a moment to shout out to people at the Secretary of State. Hyla Wagner, former general counsel here, but she is an attorney with Secretary of State, and Linda Cassidy, former in education. She's with Secretary of State. They helped a lot. They did a lot of the legwork to come together to help with these codes. So I really appreciate them. But it is, as kind of said, the partnership collaboration where we're working together constantly to make sure we're each meeting each other's needs and to get the project to a successful landing point when we get there.
Thank you. That's encouraging. Answer my question.
Commissioner Wilson?
Yeah, I just wanted to add an additional point. Excellent, presentation and summary. When I came on the commission in 2019, I recall 2020, this issue was a major challenge, and I know there was a presentation that was made by the Secretary of State's office that I don't know if there's a copy of that, but I think that Commissioner Brandt would find that presentation to be very useful in terms of the historical context of CARS and how it's evolved. But the challenge of implementing it is something that I think will definitely satisfy within the next year or so. It's my understanding.
We're hoping. We're gleefully hoping that this is on its way, and that's why we're presenting these things to you now, and may have more things coming forward before the commission as the system is getting closer and closer to launching. As Galena talked about, Executive Director West, they are doing wireframes, they're getting closer to kind of making decisions about how the system will look for the filer, for the public. And so we're highly involved in those discussions because we want to make sure that that is meeting all of our requirements and something, again, that enforcement is able to do what they need to do with.
Because some of these challenges go back at least 5 years, to say the least.
At least. But we're getting there. We're getting there. I did print, there's a lot of paper here. I did print out in case there were questions on it.
Great. Do we have any public comment? Okay, and just to clarify, so we're going to do a motion to adopt the revisions of the expenditure codes. Was there an additional specification you wanted
Yes,
us to include in
please.
there?
In the descriptions for office expenses, office postage is listed, and I am someone that likes to make things clear. So I think having just one code for postage would be preferable. And so if we remove office postage from office expenses, then people, if they have postage, would just use the postage expenditure code. And office expenses would be expenditures for office rent, utilities, including cellular phone and internet service, office equipment, computer, printer, office supplies, delivery, and messenger services. And so postage would be separate to be its own code.
Okay, that's helpful. Does anybody want to try to take on that motion? No, I'm just kidding. I'll go ahead. Then I'm going to go ahead and move that we adopt the revised expenditure codes, right? As well as the descriptions with one revision, and that is that we remove postage from office expenses under the descriptions.
Perfect.
Okay, do I have a second?
Second.
Ms. Bo?
Second.
Commissioner Baker,
Aye.
Commissioner Brandt,
Aye.
Commissioner Ortiz,
Yes.
Commissioner Wilson,
Aye.
Chair Silver,
Aye.
motion passes.
Executive Director West?
Hi, we are having a slight technical problem with our YouTube, so I just wanted to make note for the record that Mr. Michael Cannings from San Francisco Ethics, all of his comments were not on YouTube during the video. So I'd like to point out that his comments were identical to his letter. So for the record, for the transcript, then that's been made out, and IT would like 5 minutes to get the issue resolved before we move on.
Okay, then we are going to go into recess for 5 minutes.
Can I make a funny comment about this?
Go ahead.
Microphone on. We're gonna make
Yeah.
What's our
You're removing pot holders. All of us were old timers.
Well, yeah.
Remember the pot holders?
Yeah.
Okay, well, we're going to go to recess until 2:18.
Hey, Jesse, can you do a quick audio check?
Yes, can you hear me? Yeah, I can hear it on the YouTube now.
You can hear yourself?
Yes. Test 1 2 3 4. Test 1 2 3 4.
What's that? Testing 1, 2, 3. Testing 1, 2, 3. Testing 1, 2, 3. I don't hear it.
Okay, perfect. We are back from recess. It sounds like we're continuing to have some technical difficulties with our YouTube broadcast. We're going to obviously continue to accept public comment via our portal online. If you're not able to, for whatever reason, provide public comment on the portal online, which would be what we recommend given our technical issues, you can go ahead and call in, and then we will reiterate what it is that you're commenting on, so the public is aware of that. So we're going to go on and move to item number 11. And that's going to be discussion of possible FPPC response to wildfires in Los Angeles and Ventura counties, including regulatory and legislative action. We're going to have General Counsel Dave Bainbridge presenting to us on that. And as a former Los Angelino, I think I'd be remiss in not re-emphasizing that if you need resources from the state of California, County of Los Angeles, et cetera, you can go to the OES website for Office of Emergency Services. There's also a specific website that was created by the governor's office where you can find resources, have questions answered, all of those sorts of things. So there's a lot of resources out there for you to consider. And thanks again to all the first responders, law enforcement, and media who have covered this set of tragic circumstances. It's really unbelievable. And thank you for Los Angeles County reaching out to us and raising this issue. So I'll turn it over to our general counsel.
Sure, I was just gonna note, the commission had asked us at the last meeting what potentially we could do to extend the deadline on some SEI filings for those affected by the wildfires. Since that time, the governor has issued an executive order extending the filing period for SEIs for leaving office and for assuming office. Those are two statements that we don't dictate what the deadline is, the statute does. So the governor has issued that executive order extending that time. He also issued an order extending the time for filing behested payment reports for those down in Los Angeles County. So the piece we have left is if the commission wants to consider extending the time period for those who have to file SEIs, the annual SEIs, by April 1st of this year. Simon Russell from our legal department is going to present on possible regulations the commission could adopt to effectuate that.
Excellent. And just so the public's apprised of what those extensions were, could you confirm those, the behested payment reporting deadline extension as well as the assuming and leaving?
Yeah, the 60 days, I believe is what it said.
Okay, great. Mr. Russell?
Good afternoon, Chair Silver, Commissioners. I'm Simon Russell, Commission Counsel, Legal Division. You heard from my colleague Valerie earlier this meeting describing to you what Form 700s are. She went into a lot of detail, so I'll just give the 10-second overview. As you know, many state and local officials are required to file a Form 700 listing various financial assets of theirs that could potentially create a conflict of interest in their position. They are required to file these Form 700s upon assuming office, upon leaving office, and to file an annual update to those forms. Now, the deadline for when they have to file the assuming and leaving office is set by the legislature under statute. The deadline for when they have to file their annual updates is set by you via regulation. Usually that deadline for the annual filing falls on April 1 for most officials. There's a very small subset of statewide officials who have to file by March 1. For most people, it's April 1. Now, at your last meeting, you asked staff to come to you with a proposal to potentially extend the annual filing deadline for officials impacted by the recent wildfires in Southern California. So that's what we're doing today. We're bringing to you for discussion only two alternate proposals for a regulation that would do just that. As General Counsel Bainbridge was describing, the governor has declared a state of emergency in two counties, LA County and Ventura County, as a result of these wildfires. Just last week, the governor issued an executive order extending the deadline for the assuming and leaving office Form 700s, the deadlines that are set by the legislature. He extended those by 60 days. The order did not mention the annual filing deadlines that you have the ability to impose. We are proposing two alternate options for regulations that could address this situation. Before I go into those, I want to note that we do have precedent in this commission for extending the deadline in response to an emergency.
The last time we did this was during the COVID crisis in 2020. Again, we extended the annual filing deadline for 60 days in response to COVID. One difference between what we did then and what we're doing now is back in 2020, we utilized what are called the emergency regulation procedures to extend that deadline because, as you recall, the COVID lockdown started around late March, and SEIs were due within about 10 days from then. So we didn't have time to go through the normal regulation process, so we used the emergency procedures. That's not what we're doing this time. We have enough time right now, if we want to go through the regular regulation process to extend the deadline for impacted filers. You'll see on the agenda that we had brought you two different options for how to address the situation, called option 1 and option 2 on the agenda. Now, option 2 is the narrower one. It's just a one-time 60-day extension similar to what we did for COVID. For filers who have their primary residence, their primary office, or their filing office located in LA or Ventura counties. Option 1 is wider. It was meant to give this commission the ongoing authority, not just one time, but ongoing authority to make rapid streamlined extensions to the filing deadline as emergencies might come up in the future. Since we posted these two options, staff has reviewed option 1, the one for the ongoing authority. We have determined that this might potentially be at odds with some of the procedures that are given in the Administrative Procedure Act. So we are no longer recommending or supporting option 1, the ongoing authority. Instead, we are, as staff, recommending if this commission does want to do anything to address the wildfires with regard to SEIs, that you should go with option 2, which is the one-time extension for 60 days. Again, I would note 60 days is the extension that this commission gave to filers back in 2020 during COVID. It's also the same extension that the governor has given for the annual and leaving forms. To clarify procedurally, we're just discussing this item today. You're not voting on it. If you want, we will come back to you in March for you to actually vote on this, but we wanted to kind of take your temperature now as to how you feel about both of these options. Again, we are not any longer recommending that you go with option 1, the ongoing authority. We're just recommending option 2, the 60-day authority. I am available for any questions that you might have. It would help us to know if you still feel that an extension like this is necessary. I would note we did get a public comment from the LA County filing officer. He sent us some statistical information in support of providing this extension. It would help us to know if you do want to go with this extension, if you think it should be just for LA County filers or if it should be for LA and Ventura County filers as well. I would note that the governor's emergency order last week applied only to LA County filers. Just so you don't get confused, when the wildfires first broke out, the governor declared state of emergency in LA and Ventura counties. But last week, he just extended the deadline for LA County filers for their annual and leaving office Form 700s. I'm sorry, for their assuming and leaving office Form 700s. It would help us to know if you would like us to kind of match what the governor did and just have it be for LA County, or if you want it to be for both counties. And of course, whether you still think the extension is necessary at all. So I'm available for questions, but I will turn this over to you for your discussion.
That's helpful. Thank you, Mr. Russell. One thought just right off the top in regards to option number 1, since that's not being recommended by legal division for adoption anymore. That type of framework, I would suggest we include it. And I guess this is more to your colleague, Ms. Nakano in the back. I would recommend that we include something similar to that in legislation, right? A specific framework with criteria that we consider in the future deciding whether to issue as a commission one of these extensions. Because my main concern with taking these piecemeal is that it's going to appear to the public as arbitrary, and we're sitting here picking winners and losers. So I'd ask the legislature to introduce legislation that would provide a guideline for us to make this decision in the future, assuming they feel that it's appropriate. Before we move on to option 2, any thoughts on that proposal? Commissioner Baker?
Thank you, Mr. Chair. And we had some discussion of this in law and policy, just for the public to know as well, and our colleagues. I would have agreed to just focus on option 2 to begin with, keep it simple, keep it clear. My personal feedback is, given the latest update from the governor, to be as consistent as possible, so there's no little tiny bit of confusion at the local level. Los Angeles County, I think at the last meeting, even last week at Law and Policy, I inquired about, what about San Diego? What about Ventura? That's my feedback. And the fourth is on seeking the legislature to determine, is it that we currently have authority to, if we do it correctly, come up with a emergency procedures of our own, or do we not currently have authority, and there's a thought that maybe it's necessary to come, there's prudential, which is better to have the legislature weigh in on, but then there's, do we have the legal authority now, or do we not, to come up with an emergency process to govern this in the future?
We could come up with an emergency process, but it would have to comport with the emergency process that's already given in the Administrative Procedure Act. I mean, I could read it to you if you want, but it says that you have to, I'm kind of paraphrasing, but it's in section 11421 of the 1974 version of the APA, which governs the FPPC's regulation process. It requires a state agency to make a finding, including a statement of facts constituting the emergency in writing, that the adoption of a regulation or order is necessary for the immediate preservation of the public peace, health, and safety or general welfare. The regulation or order of repeal may be adopted as an emergency regulation. So in other words, you would have to, under that rule, you would have to hold a meeting, you'd have to make an emergency finding that this is necessary to preserve public peace, health, or safety. And whereas the option 1 that we had presented to you envisioned either giving the chair the authority to do that outside of a meeting, or allowing you to do that in a meeting, but using the definition of emergency found in a separate section of the government code, which is wider than what's found in that sort of imminent danger standard under the currently existing APA. So the one sentence answer to your question is, technically we could, but it would have to comport with what's already given in the APA, and option 1.
Thank you.
We don't believe does that.
Very helpful. My just thoughts on that, as this I know will be the subject of further discussion, most likely is that there's going to be a balance. The legislatures may give us some guidelines or authority, and that we make it not too rigid and ask them to get too narrow on the circumstances, so that the agency can be nimble as possible. And the second is that if there's conversations about, should the chair have the authority or the commission, we had talked about this at Law and Policy, that we both felt more comfortable with the commission. You know, we've had quick commission gatherings all together. We live in a modern world. We hopefully, if there is ever something that requires it, we can get enough people together under all the other rules rather than put it all on the chair. And then the chair would have the benefit of multiple voices. There's a benefit to having perspectives from other colleagues who will spot problems and ways to implement. So that is the other feedback. And the last one is the people who are due to file on March 3rd. I think I had raised this in Law and Policy and even in the last meeting, and you might have addressed it in the first few moments this afternoon. Whether they live in LA or not, they're going to have to file March 3rd. Is that right? Okay. They're just having to stick with that deadline is what I understand. And it's a more narrow group of folks, if I remember correctly, but it does include the legislature.
Yeah, sorry, I'm nodding my head.
Yeah,
Yes,
I see you nodding
correct.
over there. So yeah. I'd originally expressed I would have been fine with extending that. There's a large delegation down in Los Angeles, both the Senate and the Assembly. They haven't asked us for this. It may be too late. Maybe it's not possible, but I just want to say that that's a deadline I would have been comfortable with also extending. I don't know if the governor has the ability to do that in his work, and if we'd want to put in that request, maybe they can. I'm just mindful of the March 3rd people, so thank you for letting me voice my thoughts.
That's helpful. General Counsel Bainbridge, any thoughts on that point? Do we have discretion to change the typically March 1st deadline, but this year it's pushed back because of it's on a weekend or holiday, something like that?
We didn't have time to notice a regulation and get it approved before the March deadline. We had time to do it before the April deadline. So that was the issue with extending that one. We didn't have time to to follow the notice procedures to adopt the regulation.
Okay, that's good to know. I'd encourage any March 3rd filers, if they're having the same sort of difficulties that we've heard from LA County and from assuming and leaving office filers, that they let us know, and then we can consider what actions to take. I think by extending the deadline rather than offering waivers from penalties is the right decision here. I think a violation of the act is a significant finding, and just waiving someone's fee afterwards, I don't think that sends the correct message when it comes to that point. If the only option we have for those March filers is taking, an approach where there's mitigation in terms of providing a fine, that's something we can consider. But like I mentioned, I'd encourage March filers to reach out and let us know if they're having trouble getting a hold of that information. Are there any other comments from commissioners? Okay. Is there any appetite from commissioners to pursue option number 1, given the legal division's recommendation that we not adopt? Commissioner Brandt?
I think given the different ways that we would have to do it, I think it would make sense for us to do some. I share your concern about picking and choosing who gets a waiver. So I think that there's some process would do that. But I'm going to leave it to staff to figure out whether that's legislation or whether that is some way we can do that. But I think there needs to be some way that we're clear and we're consistent, because we're going to get more emergencies, more wildfires, more, floods, every kinds of things. So we need to have that. With climate change, it's just inevitable. So that's why I'd say we need to be prepared for that. It's a climate change response. That's what it is.
Agreed, and all sorts of crises. So you're absolutely right. Okay, so moving on from option 1, so we have option 2. How does the commission, outside of Commissioner Baker, which sounds like she's okay taking Ventura County off of the, I don't want to speak for her, but any other thoughts on that? Are we okay with limiting this to LA County as the governor did?
I agree with going in tune with the governor.
Okay.
That was my.
Ditto, same.
Okay. Okay, great. So we have consensus on both of those items. I guess while we have 5 commissioners here, it's worth saying that, I believe that this should be a determination made by the commission if we're going to provide this as an idea for legislation. So that would be my position. I don't know if there's any other thoughts from commissioners. I think it's important for us to come to consensus when you're talking about extending deadlines. So that's my reasoning there. And while, I highlighted the fact that I'm not a fan of us being in the business of picking winners and losers, I think this is obviously a case where we want to do everything we can do to accommodate those affected by these fires. I was just pulling up the statistics, and the Eden fire in Altadena and the Palisades fire in Pacific Palisades are 2 of the most destructive, are number 2 and number 3 in the top 5 most destructive fires in the history of California. So in that circumstance, I am comfortable signing off on approving at the next meeting an extension of the annual deadline for April 1st filers. Thoughts from other commissioners? Okay. Then why don't we go ahead, and we don't need to make a formal motion, but we will ask for public comment. Is there any public comment? Okay. Then, is there any other information you need, Mr. Russell, before we move on?
No.
Excellent. And one last thing, did we mention, so governor's office extended by 60 days, leaving office, assuming office filings, as well as behested payments.
And behested payments, yes.
When does that extension expire? Is that April 1st? Is that April 30th? I forget what the date is. And while you're looking that up, I'm not sure if it's going to trigger our ex parte rules, what have you, but I think the public would be happy to know that we've been working closely with local officials, with the governor's office, with the legislature to make sure that the concerns of LA County in terms of filing this paperwork is addressed. So this is something that we worked with the governor's office. They did not leave out this piece of the reporting extension because they felt like it wasn't appropriate. We had indicated this is an area where we do have authority to make that extension.
Right. And the governor's extension came via Executive Order N1725. In paragraph 11, it doesn't provide an actual sunset for it, but it says any deadline on or before April 1, 2025 for public officials in Los Angeles County to file the following reports or statements is extended by 60 days. And then it lists 3 types of filing: the assuming office, the leaving office, and behest of payment, but doesn't provide any kind of date for repeal or sunset.
Okay. Okay, that's helpful. Perfect. Well, thank you, Mr. Russell. Thank you, Mr. Bainbridge, and for the legal division making this a priority.
Thank you.
Now let's move on to item 12, Form 807 discretionary audit results. We're going to invite our Chief of Audits and Assistants up, Sharada Shah. Good afternoon, Ms. Shah.
Good afternoon, Chair and Commissioners. Let me just get set up. PowerPoint.
While you're getting set up, I think it's worth noting that we are also sending out information to the individuals in Los Angeles County, updating them on these changes, making sure they're apprised of them, as well as providing them with fact sheets, or at least a fact sheet that kind of addresses how the law would be applied in the circumstances that they're dealing with. So with that, I'll throw it back to you, Ms. Shah.
Okay. Good afternoon. I'm Sharada Shah, Chief of Audits and Assistants, here to provide an update on the discretionary audit for Form 807 that we had recently conducted. It's not working. Okay. Thank you. Okay. Before diving into the report, I'd like to highlight that the Audits and Assistance Division operates independently within the FPPC. Our division conducts both mandatory and discretionary audits as permitted by the Political Reform Act. Mandatory audits are conducted under Section 90,001 of the PRA, while discretionary audits are conducted under Section 90,003. Now, turning on to the details of this audit, I will cover its purpose and the relevant legislation, the audit process and methodology, challenges encountered by the audit team, and finally, the audit findings and recommendations. I'll be happy to answer any questions you may have at the end of the presentation. In November of 2023, under the direction of the Executive Director of the FPPC, the Audits and Assistance Division initiated the discretionary audit to verify compliance with reporting requirements provided for in the Government Code Section 8950C-506F and Regulation 18940. As mentioned earlier, Section 90,003 of the PRA permits the Commission to conduct discretionary audits. The purpose of conducting this audit was to gain information regarding the application of the current reporting requirements that would assist the Commission and Legislature in evaluating the effectiveness of those requirements. In addition, the audit was conducted to determine if the current rules are meeting the goal of publicly disclosing gifts of travel by nonprofit organizations. The Form 807 is currently used by 50C3 and 501. The Form 807 is currently used by 501c3 and 501c4 nonprofit organizations that meet each of the following criteria. Number one, they regularly organize and host travel that is reasonably related to a legislative or governmental purpose, or to an issue of state, national, or international public policy for state and local elected officials. Number two, they make travel payments, advances, or reimbursements totaling more than $10,000 on a calendar year, or totaling more than $5,000 in a calendar year for a single state or local elected official. And the third one is have donors of $1,000 or more who accompanied an elected state or local official, either personally or through an agent, employee, or representative for any portion of travel. By definition, an organization regularly organizes and host travel for elected officials if their organization's expenses that relate to that travel, state study tours and conferences, conventions and meetings with regard to the elected official were greater than were greater than 1/3 of its total expenses reflected on the organization's IRS Form 990. I'll speak briefly about the original legislation regarding this requirement. So SB 21, Chapter 757 was passed in 2015 to amend the Political Reform Act of 1974 to increase transparency in the disclosure of gifts of travel provided by nonprofits to public officials. SB 21 required nonprofit organizations that pay for specified types of travel for elected officials to disclose the names of donors responsible for funding the travel. The bill also required an official who receives a gift of travel payment from any source to report the travel destination on their statement of economic interest. The intent was to improve public access to information about these gifts and ensure compliance with disclosure requirements. The goal of our audit was to gather the above-mentioned information and educate entities who have not been filing the required form, inform the Commission of problems with the existing statute, and suggest improvements to the Form 807 requirements. So now we'll move on to the audit process. To begin with, the Commission's executive researcher obtained a download of the 2022 Form 700s filed with the Commission by Assembly members, senators, constitutional officers, and coastal commissioners in office at the time. The filers disclosed relevant information, including trips, travel, reimbursements, study expenses, etc., on their Schedule E of their Form 700s. The Audits and Assistance Division reviewed and analyzed the downloaded data and grouped the details by organizations disclosed on the Form 700s. We selected 10 organizations with expenses of $20,000 or more. For testing, 8 of those were non-filers, and 2 were the ones that have filed a Form 807 for either 2021 or 2022. The organizations that were selected are included in this slide. We sent out the initial contact letters to these organizations on January 4th, 2024, requesting the following documents. We requested the Form 990, 990EZ, 990PF, and any Forms 990T filed, supporting documentations and schedules, application for exemption, IRS determination letter for tax-exempt status. Not all organizations had complied with this request. I will discuss this in a later slide. Once we received the information from the organizations that initially complied, we verified if the organization had an approved tax-exempt status per the IRS determination letter for that organization. Next, we reviewed the Form 990, 990EZ, 990PF, and any Form 990T filed for 2021 and 2022. We cross-referenced the amounts to supporting documentation, Form 700, and Form 807 where possible. The supporting documentation we requested were source documents for payments related to travel, study tours, conferences, conventions, and meetings, advances, and reimbursements. These included invoices, receipts, canceled checks and bank statements, contracts or agreements, and credit card records. These were requested to support the dates, destinations, amounts, purpose for each expense, and the state or local elected official or the office holders who were accompanied on the travel. We then calculated and verified the amounts reported for travel and all the direct expenses that met the one-third threshold for the requirements of Form 807. A detailed calculation and analysis was performed by the audit team where possible, and the amounts were traced and cross-referenced as indicated before. I will next go over some of the challenges and the roadblocks that we had faced while performing the audit. as soon as my slide moves.
Are you able to just press the right key on your computer?
Oh, no, it's been projected from there.
Okay.
Okay, there it is. Okay, so the first challenge we ran into was lack of cooperation from some of the organizations. This led to multiple follow-ups and escalations for our request. Additionally, the audit team had to work with our enforcement division to issue multiple subpoenas for necessary documents. As a result, this resulted in the audit taking longer than anticipated to complete. The second challenge that we ran into was inadequate documentation provided or incomplete data that was provided. Some of the documents we received did not fulfill the requirements. In some cases, we received an internal spreadsheet rather than an invoice, or a document copy with key information blacked out. For all of this, we had to go back to the previous step of re-requesting the documents or working with the enforcement division to send out a subpoena. We also had lack of documents for direct costs. Some of the costs that were listed, we lacked the documents for indirect costs. Some of the costs that were listed as miscellaneous costs, these were not explicitly categorized. Due to lack of proper breakdown, there was no possible way for the team to track these amounts and then trace them back to source documents. Indirect costs on the Form 990 are not explicitly categorized and are reported under general categories such as management and general expenses. This made it even more difficult for the team to go from one cost and try to see who would have attended, who would have been on a travel. So there was no way to trace these. Once all of the documentations were re-requested and wherever we could, I'm sorry? Yeah. Alvin, do you mind going to the next slide, please? Thank you. Once all of the audit fieldwork was completed, we compiled our results, and the results are summarized on this slide. Based on the procedures that were performed, the 501c3 and 501c4 organizations audited did not meet the 1/3 filing threshold. As far as the 501c6 organizations were concerned, the results were inconclusive. Section 89506, as currently written, does not apply to 501c6 organizations. Per consultation with our legal division, the audit division did request documents from 501c6 organizations to assist us with our evaluation of the proposed legislation and its purpose. However, those documents were not provided, so our results in that area were inconclusive. The audit results are also summarized in the audit report that has been posted in the commission meeting agenda for today. Next slide, please. Based on our audits, the Audit and Assistance Division recommends the following. We recommend eliminating the 1/3 total expense thresholds. We recommend eliminating the $10,000, $5,000, and $1,000 thresholds. Instead, replace the thresholds with a desired flat amount that requires nonprofit organizations to file a Form 807 if they make the expenditures above this set amount. This will allow FPPC to see the form per Form 700 which organizations should be filing a Form 807. Require disclosure of direct costs. Require organizations to disclose direct costs made for officials' travel, hotel, rounds of golfs, or similar expenses. This allows for public transparency as well. And then expand who must report under Government Code Section 89506F and Regulation 18940. Staff recommends expanding this requirement to require all nonprofit organizations to file a Form 807 if they meet the above requirements. So this concludes my presentation. I will be happy to answer any questions you may have.
That's great. Thank you for that thorough analysis of the audit. And please relay along to your staff our appreciation of their hard work in this area. So as I understand it, sounds like the legislature in 2015, they decided there's not enough transparency when it comes to gifts of travel to state and local elected officials in terms of who's funding them, the real true source in their opinion. of these gifts of travel. So they adopted this new law. We created a new form where those donors would be disclosed. We did not see very many filings
We did
of
not.
these forms, right? Was there two
No.
up until a couple of years ago?
When we initiated the audit, there were 2 files and 2 reports filed.
Okay. So now we're considering what our advice would be to the legislature in changing, if at all, the thresholds, the expenditure thresholds, the percentage activity thresholds, so that enforcement can make a determination as to whether disclosure is required with not so much staff time and analysis and waiting for documents to come in. Is that right?
That is correct.
And from doing all these audits, from conducting all these audits, were there any numbers that you or your staff arrived at that you thought would be a good baseline for a threshold, or is that something that we're still considering and analyzing?
We're still considering that. We have not proposed a firm number from our side. We would like to consult with Executive Director and the commissioners on that.
Okay. Okay, excellent. Well, that's all really helpful. Commissioner Baker?
Thank you, Mr. Chair, and thank you for this work. I'm really pleased to see that this audit happened. The team persisted, persevered, and engaged the support and from the enforcement team as necessary. And I do have a couple questions. First is on your finding that the 501c3 and 4 organizations that you indicate in your report and presentation that did not meet the threshold of 1/3. What is your level of confidence in that? Is it based on what they gave you, or you felt like you had all the information you needed, and based on all the information, it was determined it wasn't 1/3? Because you identified how the amounts of information you got was spotty with some.
Based on what information was provided, in most cases, we did receive invoices and source documents that we were able to trace to. In certain ones, we did receive spreadsheets. So based on what staff could work with best and their analysis of that information, we were able to come up with this information, with the results.
Yeah, and I can't obviously speak for the organizations. In some ways, some of these are very well-known, established. They'll have legal teams, fundraising sources, and so on. But there'll be nonprofits out there that are really dinky and don't have folks to do more than create a spreadsheet that maybe a volunteer has been keeping together. Not great, but possible. So the next question I have is on the threshold. The chair has asked if you kind of had any thoughts. The threshold being the flat monetary amount. With your recommendations, I should pause. Full disclosure, I was there in 2015, voted for that bill, and it was a goal to bring more transparency where there had not been before. And I don't remember there being, I was involved in the debates on 1/3 threshold, so that's just for fair disclosure. I do think it would be great to just make this a lot cleaner, simpler, a lot less back and forth and potentially maneuvering or missed information about 1/3 or not, just hit a flat level. My question that helps me kind of determine what feedback I have for what that flat level would be is if in what you've seen, the expenditures tend to be multiple electeds and folks, tickets, or one person at a time. And the reason I am asking that for travel, the reason I'm asking that is if it tends to be mostly multiple people, then a $5,000 threshold might be right. It's going to trigger early enough, but maybe not catch the one-off where a nonprofit is once paid for travel. It doesn't get really small instances. So do you have a sense of if most of these folks, I can tell by looking at some, but others I don't know, would have maybe 50 people, 20 people whose travel costs they paid for, 10 or 1? Were you able to determine that at all?
It is multiple people because these are all related to conferences or study tours or where it's always more than one person.
More than one person.
So in all instances, it was always more than one person.
Well, I would be supportive of removing the 1/3, having a percentage that is just keep it simple. And as this commission goes forward and considers what other adjustments to make, if any, I would always keep in mind what loophole might be getting created. How are they trying to work around it? which is, well, it's 5,000, but only if it's this type of travel or that. Water goes where it can creep through, even with the well-intentioned folks. I think my last question is about the process. The fact that you identified you had to get subpoenas, and then you get information that wasn't very helpful and you had to go back. If somewhere down the road you have any recommendations for any authority that you, as at the audit division, might need, this is a great way for our audit division to be utilized. And there'll be other studies and audits the commission may want to do. It'd be great to have any other process in place that you wish you had had in this instance that you don't have now, so that our team can request that through legislative or regulatory authority. That's it. Thank you.
Thank you.
Any other commissioner comment? Any public comment on this item? Okay. Hearing and seeing none, let's move on to our next item, which is going to be item number 13, which is 2024-2025 fiscal year second quarter expenditure report. We're going to receive a presentation from Chief Administration Ju Wang. Just to clarify, not necessarily a presentation, but she will be presenting.
Yes, no presentation.
Commissioner Baker?
I just want to say thank you again for the audit report. And then is just if there's any, is there any further direction to the about adopting some of the recommendations or considering them in the future? I won't be here, but I'm dying to know what you think might come next.
Sure. Well, I'm interested to see what the numbers are that the audit division feels is appropriate for the threshold. I think this is a kind of a tricky area, right? Because you just have so many nonprofits out there. Some are more sophisticated than others. And I want to make sure that we're erring on the side of transparency, but we're also not creating a trap for the weary, which I feel like is that a phrase that I picked up from
Not
you?
for me. Don't blame me on that one.
Somebody gave me that phrase. I wanted to credit them. So I wouldn't want to create a trap potentially for nonprofits who do a single trip, that sort of thing. Not the sort of activity that I think was the intent of the legislation and Mr. Hill. It was Mr. Jerry Hill?
Jerry Hill, Senator Hill. I don't know if it was that it would be just one trip. It could be just one trip because you can have 40 members go on one trip.
Right.
And if the public does want to know, one trip happened to Italy or Hawaii or wherever, North Dakota, and that's the information that they like to know. Could have been a first class trip, could have been a perfectly legit trip, but I'm grateful to know that there'll be more going on.
Yeah. Nonetheless, I think it's important that we get the data in front of us, chat with stakeholders, Cal Nonprofits, Common Cause, all the relevant stakeholders, and see what their analysis shows as well. So I think this is an ongoing project. As you mentioned, we did sponsor legislation last year, which died in the Senate. And now we're back at the drawing board. So hopefully we can identify that number and then go forward from there. But I agree with Commissioner Baker. This is definitely an important policy in an area that's important to Californians. Thank you. Dr. Wang.
I would like to present the second quarter expenditure report as it is. I'm happy to answer the question you may have.
Commissioner Wilson.
Yes, I was looking at your report, and these are big numbers.
Yes.
So thank you for your report. But I did want to ask, in terms of 2025, you clearly outlined, Chief Wang, the different funding, appropriations, and budget allocations. How does, just generally, these numbers compare, for example, to last year's budget?
So this year compared
To 2024.
So 2024 compared the last year, which is 23-24.
Oh, okay, I'm just 25, 26, 23,
24.
23, 24 is what I meant to say, thank you.
Okay, so next year will be 25-26. That's what next report will be governor budget. So compare this year. So there's a potential 555,000 general fund increase and 3 additional position increase for next fiscal year, which 25-26.
Okay.
Yeah, so this is increase in come from the BCP budget change proposal we submit last fall to cover the implementation cost for the various legislation bill passed last year. So 555,000 increase potential for next fiscal year.
Okay.
And what about fiscal year 23-24?
23, so compared current year with the past year, I believe there's another BCP. So every year our budget's increasing because all the BCP we submitted to cover the legislation cost.
So just roughly, just generally speaking, you have the 2025-2026 governor's budget. What is the increase for this 2025-26 budget compared to the prior fiscal year?
So compare the current year with the past year, I believe there's the percentage is not higher. I think we increased 300,000 based on the one BCP.
Okay.
So every year based on the number of the PCP, so we have the budget increase.
Okay. Yeah, my main concern is that, I'm not advocating for more money, but I just want to make sure that we have enough funding to meet the demands of the FPPC in terms of staffing, workload, et cetera. So that's my biggest concern.
Yeah, definitely, because next year we request 555,000 to cover various bill, which is 5 bill. So we might not have enough fund. So we're gonna keep tracking the workload, and we plan to submit another BCP if we do foresee the insufficient fund to cover all the legislation bill.
All right, thank you.
Any other comments from commissioners? Commissioner Brandt?
Question about, I must be reading this wrong. So does this really show a 50% surplus, or is this, so the report that is the, on fiscal year budget summary, the total budget was 18.6 million, and we've only spent 9.9. Am I reading that right?
Oh, that's just for the second quarter. So we kind of halfway. So we have 50% budget left.
Okay.
So we are very balanced.
Okay, thank you.
Yeah.
Okay, sorry, just wanted to make sure I read that right.
Any other questions from commissioners? Okay. Any public comment on this item? Okay, then why don't we move on to item number 14, which is also going to be Dr. Wang, and that's 2025-2026 governor's budget.
Yes, so I think I kind of mixed with Commissioner Wilson's question. So now it's 25-26, or before 23-24 compared 24-25, yes.
Yeah, go ahead.
Yeah, so as what you can see, so 25-26, we have the increase 555,000 general fund increase because the BCP was submitted to cover an implementation cost for various bill past 2024. Yeah, so that's our concern. So because the funding might not be sufficient, but we always have the chance if gonna tracking all the workload. If not sufficient, we're gonna submit another BCP next fall to cover all the cost. Hope this answer your question.
And the BCP can be denied, right?
Yes, that's why I said there's a potential increase 550,000 because this year finance have the different approval process. So they put all the potential adjustment into the governor budget and gonna reevaluate during the May revision, which is now. So until the governor signed the budget in June, everything's possible. So they still gonna reevaluate all the adjustment based on the availability of the funding. But that's what we have right now. It's 555,000. That's what we request.
Okay, that's helpful. Any other comments from commissioners? Questions? Any public comment on this item? Okay, hearing and seeing none. Thank you, Dr. Wang. We're going to move on to item number 15. And for that, it's the legislative update. So we're going to welcome up our senior FPPC Legislative Counsel, Lindsay Nakano. Good afternoon, Ms. Nakano.
Good afternoon, Mr. Chair, Commissioners, and welcome to the FPPC, Commissioner Brandt. I'm Lindsay Nakano, Senior Legislative Counsel for the Commission. Today, I'll give an update on the 8 Political Reform Act bills that have been introduced in the legislature so far. 3 of those bills are listed in the legislation report, and 5 were introduced after the agenda posting, but I'll go over all of them today. Of the 8 bills, 2 were Commission initiated so far, and I'd like to ask the Commission today for a vote to support both bills later on in the presentation. Going in the order in the report, I'll start with the 3 that are included in the written report. AB 359 by Assemblymember Ramos extends the operation of an existing section that is set to sunset on January 1st, 2026. The bill was Commission initiated, and this is the first of 2 bills that, as I mentioned, I'll ask the Commission to vote on to support. For background, existing law authorizes the FPPC to contract with local government agencies upon mutual agreement to administer, implement, and enforce the agency's local campaign finance or government ethics laws. This section is set to sunset at the beginning of next year. Pursuant to this authority, the Commission currently has 1 active contract with the City of San Bernardino, and staff would like to retain this authority moving forward. So with that, I'll pause for any questions or discussion, and then would ask for a vote to support this bill.
Any questions from commissioners? It's my understanding we've gotten excellent feedback from the City of San Bernardino. We've been working with them for quite a while now, and the author's office represents this area. They received the same feedback that we did, so I think this is a common sense, good bill, and I would support it. I would ask the Commission to support it.
Yeah, second.
Excellent. Ms. Vo?
Commissioner Baker?
Aye.
Commissioner Brandt?
Aye.
Commissioner Ortiz?
Yes.
Commissioner Wilson?
Aye.
Chair Silver?
Aye.
Motion passes.
Okay, I guess we can move on to the next bill. Just in case, is there any public comment on that bill on 359? No, okay. Okay, continue, please, Ms. Nakano.
Thank you. The next bill is AB 26, and this is currently a non-substantive intent bill that may be amended in the future to substantively amend the Political Reform Act, and I'll keep the Commission updated on any amendments. AB 351 by Assemblymember McKinner. This bill would make a change to Section 84308. For some background on that section, Section 84308 generally governs the disclosure and disqualification requirements that apply when an officer of an agency has received contributions from a party or participant in an agency proceeding. Currently, the contribution limit that triggers these disclosure and disqualification requirements is $500, and this limit was just recently raised by legislation last year from $250 to $500. AB 351, this year's bill, would raise that contribution limit from $500 to $1,500 and would require that limit to be adjusted every 2 years according to the Consumer Price Index. And I've reached out to the author's office for background, fact sheet, haven't heard back yet, but I'll keep the Commission updated on their rationale.
Okay, great, that's helpful. Commissioner Baker?
Thank you. Just something to consider for future debate or conversation about this bill. Consumer Price Index makes numbers really uneven. And if my encouragement would be that if there's going to be another increase, which I would not, if I were here, probably wouldn't support, that it be like a clear figure. And CPI is just, you get into bad figures. And the more we have different deadlines and different numbers, it's harder for people to comply. My hope is that the number won't keep going up and there won't be more and more chipping away at what I thought was good pay-to-play legislation that we worked really hard on in the regulations. But if it is, make it simpler with that. Thank you.
Yeah, and as we've already discussed, we'd welcome any sort of feedback from the author's office as to why they think that this threshold should be increased to that amount and greater. Any public comment on this item? Okay. Any other commissioner comments? Okay. Keep going.
Okay, I'll move on to the additional 5 bills that were introduced since the agenda was posted. 2 of those bills are easy ones. They're spot bills, AB 465 by Assemblymember Zuber and SB 321 by Assemblymember Cervantes, both currently spot bills. So I'll keep the commission updated on where those 2 bills go. The remaining 3 bills propose substantive changes to the Political Reform Act. SB 42 was introduced by Senators Umberg and Allen relating to public campaign financing, and similar bills were introduced in 2023. For background, existing law in the Political Reform Act prohibits a public officer from expending and a candidate from accepting public money for the purpose of seeking elective office. SB 42 would strike the general prohibition on expending or accepting public monies for this purpose of seeking elective office and would instead impose certain conditions and restrictions on the use of public funds for the purpose of seeking elective office, thereby allowing local governments and the state to impose systems of public campaign financing. The bill would also make an unrelated change to the Political Reform Act to increase the maximum penalty for violations of the provision that prohibits foreign governments and foreign principals from making contributions, expenditures, and independent expenditures. And the bill would be subject to voter approval if it passes in the legislature at the November 2026 election.
That's helpful. One thing I'd be interested in is whether eliminating that prohibition would hamper us at all in prosecuting a jurisdiction that misuses state resources for a campaign purpose. And perhaps that's something the author's office has already considered, but definitely something we want to think about before we strike that from the act. Any other comments from commissioners? Public comment? Okay.
Okay, I'll move on. The next is SB 280 by Senator Cervantes, and this is the second commission-initiated bill that has been introduced so far. The bill relates to the prohibition on receiving or delivering contributions in state buildings and offices. For background on this one, existing law prohibits a person from receiving or delivering a contribution in the state capitol, any state office, or any office for which the state pays the majority of the rent, other than a legislative district office. This bill, SB 280, would strike the exception for legislative district offices and would extend the prohibition to all state or local government office buildings and any office for which the state or local government pays any rent. As a commission-initiated bill, I'd also ask the commission for support on this one.
Commissioner Baker?
Thank you. I don't know why this didn't occur sooner. We were talking about this, but why were district offices originally excluded?
I don't have the legislative history on that. We can try to look into it, but I'm not sure how old that particular prohibition goes back.
I'm trying to wonder why. That would be,
I can't give you the exact date, but it dates back to Shrimp Scam, when there were some checks that were delivered to the Capitol. And if I recall correctly, Art Agnos might have been the author of that bill back in the 1980s.
Okay, thank you.
And we discussed that specific issue with Assembly Elections Committee yesterday, and they had a hard time finding any sort of justification for that distinction.
having had a district office, I can't imagine why it would be treated any differently, even though it is, maybe it was rented out of a commercial office building, but I can't understand why that would be treated any differently. All the same implications are there. So obviously I would support this. Just wondered what on earth would have been the justification before. So, okay, thank you.
I thought it applied to district offices, but I guess it didn't.
So there's not a statutory prohibition, but of course, different bodies are able to
I
adopt their
thought
own policy to prohibit
we
it.
never accepted a check in the district office.
Yeah. And then there could potentially be a violation of, well, I'll let the criminal folks talk about that piece. So I would ask the commission to take a position of support on this bill.
To support, or is that your motion?
I seconded, I thought it was a motion.
Sure, I'm going to move to have the commission support this legislation.
Also seconds it.
Okay.
Commissioner Ortiz, sorry.
Ms. Poe?
Commissioner Baker,
Aye.
Commissioner Brandt,
Aye.
Commissioner Ortiz,
Yes.
Commissioner Wilson,
Aye.
Chair Silver.
Aye.
Motion passes.
Okay, our last one.
All right. SB 300 by Senator Padilla also introduced. The bill would make an exception to the general conflict of interest prohibition in the Act. For background, the PRA generally prohibits a public official from making, participating in making, or influencing a governmental decision in which the official has a financial interest. One way a public official can have a financial interest is in a decision is if it's reasonably foreseeable that the decision will have a material financial effect on a source of income to the official, aggregating $500 or more within the 12 months before the decision is made. SB 300 would make an exception such that a public official does not have a disqualifying conflict of interest in a decision if the source of income is a nonprofit organization whose financial interest in the decision arises solely from an increase or decrease in membership dues. I've reached out to the member's office for background on this one, and I'll update the commission as soon as I receive that at the next meeting.
So the conflict of interest rules, I'll admit, are complicated, but they're obviously incredibly important, right? That's one of the priorities for the public, I think, is that they don't have public officials who are benefiting themselves in office financially or otherwise. I'm open to all sorts of changes to the act so long as there is a strong basis for it. Here, I'm concerned that this would create a pretty significant loophole. And again, I'd be interested to hear from the author's office as to why this is necessary, because it seems like it would be a very narrow group of officials who would be impacted by this, and it could potentially be abused. Any other comments from commissioners?
Certainly agree. And I don't know what's broken. So it'd be really nice to say, what is the justification? What is broken that they're trying to fix? Always a good question, I hope to ask. And not assuming that if you're a nonprofit and it's just to increase your membership, that nonprofit doesn't engage in, or its members engage in some form of influence or political activity in other ways. You know, nonprofits are allowed to do some amount of advocacy, and some are set up just to do advocacy. And so I would just caution us on that one. You hope you can get justifications. And if they could, third thing is if they could provide specific illustrations of the types of nonprofits to whom this would apply. I've got some suspicions, but I think that would be one question that I would have there. Thank you.
Any other comments from commissioners? We have any public comment on this item? No? Okay. Continue with your presentation, Ms. Dakota.
That concludes my update on bills, but happy to take any questions or comments, feedback.
Excellent. Any other comments generally on the legislative update? Commissioner Baker?
I'm sorry. I just wanted to say thank you for your work. I've enjoyed working on law and policy with you and on, of course, commissioners and chairs when bills have come forward, and it's a lot of back and forth. And of course, the two things you always heard from me was get those bipartisan authors. It's part of not just our image, but just a great, good thing to do. And sometimes it's hard and it's not required. And I know you'll hopefully have great success in that, and that when the commission sponsors a bill, which means the commission puts its imprimatur, its staff time and energy to really work on that bill, that the authors do take seriously the bipartisanship nature that we hope and expect, even if it's not required to get enough votes. And if they're going to make substantive amendments, that they involve us so that we're not in a situation come July, August, towards an end of session or House of Origin deadline where a deal's being made on a bill that we sponsor that we may not like, and we're potentially in the position of withdrawing sponsorship, opposing unless amended, and all that. And you've done a very good job of helping us try to navigate that. Those would just be my encouragements to keep pressing on those. Thank you.
I 100% agree with that sentiment, and I think it's important to report that we've already talked to both Republican and Democratic offices on several of these bills who are willing to co-author. I think the reason why people are willing to do that is because we're pursuing common sense policy that's good for Californians. I think everybody increases that thoughtful transparency is a goal. Increased and thoughtful transparency is a goal of everybody. So moving on to executive staff reports. Thank you, Ms.
Thank you.
Nakano. And we'll start with the Enforcement Division. Chief Enforcement Lindsay, anything you'd like to highlight in your report?
Good afternoon. No, actually, the enforcement report is as submitted, but if there are any questions, happy to answer.
Any questions from commissioners? Commissioner Baker?
Thank you. I have one that is not in the report, and it is a follow-up. And just to put this out there, in the last two commission meetings, I solicited your feedback on the political articles came out about our numbers and enforcement. There were actually two. The second article was on the papers and the storage and how difficult it was for them to get response. And anybody who's been in a public service chair knows that reporters, you always feel like after you've had an interview and you've worked with them, to give them all the information they need, that the story doesn't reflect at all what you said and what's going on. But as kind of an oversight commission, it would be wrong of us not to, after an article's come out, to inquire and ask for feedback on it. I don't know if you recall the second article. This was back in the latter part of last year. I simply forgot to bring it up in the prior commission meeting or two. It came out a couple of weeks after, and it was Cal Matters. It came out, same reporter, I believe, came out a couple of weeks after the one on how our progress and enforcement of reforms were going. And again, it really focused primarily on gaps in the records and what they thought were, how long it took to get things. Do you have would you like to say anything? I putting you on a spot a little bit, but this was a public article, or any response, or is this something for a future agenda? I leave that to my colleagues on that, because that's the first time I'd seen that type of reporting on the record keeping of cases that they felt impaired their ability to do their investigative reporting.
Yeah, thank you for the question. I don't know that I have a comment in the sense that I'm not really familiar with this second article, I guess, that you're referring to.
It got a lot less attention, but there was a second follow-up article.
The gist of the article was that they did not receive records?
It was reporting on how difficult it was. It was reporting on the details of their methodology and how difficult it was to get information, and that they felt there were gaps or the form of information. And again, to us, it may be anecdotal, and we don't govern by anecdotal. I'm just asking because as an oversight commission, it's important to say, they've raised a matter. What's our response? What really happened? How do we store those things? The audit that just happened with travel reporting with nonprofits came that kind of to light to us from the Cal Matters article from 2023. So it came out a couple of weeks after the primary article on the enforcement reforms and caseloads and so on. So I leave that to you, and I'm looking a little bit at direct arrest as well, and to this commission to decide if you want any further follow-up or response from our team on it.
I will say generally that we did receive a number of requests with respect to the first article that was done, and we were very cooperative within enforcement. I would argue that we went beyond what was required under the Public Records Act rules, and actually collated a good deal of material to give a very thorough response. I think that the records that we provided were really good, actually.
Okay.
So if there were minor discrepancies, there were some discussions about some minor discrepancies here and there, but
Well, Mr. Lindsay, let me step in for 1 second. It sounds like you didn't have a chance to read the second article. So why don't we do this, since you're looking for direction? You can go ahead and review that article, see what allegations were made, et cetera, and then just present back to the commission on the veracity of that data underlying that and what we can do to address those issues. I think that's the best way to move forward.
I can give you a short answer right now. Basically, we had a computer system back in the day in 1999, it crashed. And so all of the information that we had was piecemeal after that on what was available. So then in 2016, we got the lowest bidder as the state requires, and we got a new system. And instead of bringing over every record with its number, they made every record that existed at that time a 2016 record. So the records seem confusing because anything that was before 2016, and this is all public knowledge, none of this is hidden secrets, that it all seemed like every case originated in 2016, which made it very difficult for them to figure out the length of time that a case was open. So that was the major complaint, which is nothing that we can control because that was the system that was built for us. Enforcement and the FPPC, we are continuing to look for solutions in the technological realm in order to make our case management system more efficient, more user-friendly, more of a Google search, which is none of the things that is available at this time. So yes, we would love someone to come in and finance us for a new computer system, for agency-wide computer record retention that we can use, and it could be the state-of-the-art system, and we would love that. And in fact, my comment to them was, when we put in this BCP, we hope you're the first trumpet that we hear helping us to get the money.
Thank you, Mr. Chair.
Commissioner Wilson?
Yeah, thank you, Executive Director West. Just from an IT standpoint, information that's currently stored on our systems, is that information also backed up on the cloud or otherwise available if, God forbid, there's another crash? Is there any way that information is captured?
Yes, all of
moving
our,
forward?
yes, it's a good question. All of our IT is backed up. We have an emergency plan for all of our IT. We're on a Salesforce system, which is cloud-based.
Okay, all right, thank you.
Thank you, Executive Director West. You can go on. Any additional, anything you want to highlight?
No, I don't think so. I think everything that is in there in its normal format, I think that it's everything that we
great.
have.
Any other comments from commissioners? Any public comment? Okay, thank you, Mr. Lindsay.
All right, thank you.
Welcome back, Ms. Shaw.
Hello again.
Anything to highlight from your report?
My report is as submitted, but I do want to highlight that we had the first public draw for this year yesterday. And it was done to select lobbyist employers, lobbying firms, Senate districts, and Assembly districts. And members of the public were able to view it through YouTube. So if anybody missed it, you can still view it. The results will be posted soon, but the YouTube link is on our draw webpage.
Okay, great.
Thank you.
Commissioner Baker?
I'll just say YouTube is not as exciting as seeing a little lottery ball, you know. So encourage, if commissioners ever have a chance to see it at least once. It's quick and painless, and but kind of interesting. So thank you. Good that it's that transparent.
Thank you, Ms. Shaw.
Thank you.
And now for Legal Division, General Counsel Bainbridge.
I see what time it is. No, I have nothing to add to the report, but happy to answer any questions.
Okay. Thank you for that. Moving on to our Administration and Technology Division, Dr. Wang.
I will submit the report as it is. I just want to highlight, so in January, again, because AB 1170, we received more than 8,000 email, but as of yesterday, it's already reduced down less than 189 email as of yesterday. So thank you for everybody's hard work. SEO. Yeah.
Excellent. Well, please thank your staff. I know how hard February and March is for them. We really appreciate it.
Yes, we're going to expect more email coming.
Great. And I wanted to take this chance to welcome Vanessa Marquez as Staff Services Manager in the Legal Division, as well as Kristen, hopefully I pronounced your last name right. If I don't, I apologize, Goulet, who's an attorney in our Enforcement Division. And if any of you know any good auditors, we are looking for a senior management auditor. That is the end of my PSA. Let's move on to our Executive Director.
Okay, 2 more minutes. We are happy to present our heat map this year, and our communications director, Sherry Yang, will run you through it so you know what is on our website.
All right. So on January 29th, we released our 2024 enforcement heat map to the public. As part of this release, we share the heat map with reporters and across our digital channels. The story was picked up by NPR Cap Radio, had a total of 2 minutes on air interview with Chair Silver. He did an incredible job highlighting that in 2024, we prosecuted more than 1,000 cases statewide, totaling more than $800,000 in administrative fines. He also highlighted our proactive efforts to educate the regulated community on FPPC rules and regulations. So since, I believe, 2021, we've released this heat map at the beginning of the year. It is an interactive tool, if you guys haven't had a chance to look at it, that provides insight into the Commission's enforcement efforts. It shows the location of the enforcement activities in 2024, offers detailed information about the case, including the type of violations, case number, the month the case was on the agenda, the name of the respondent, fines, and position and title of the person being fined. So this is just one example of the direction that we're taking to provide the public with clear demonstrations on how we are working to safeguard integrity across California. So that's my presentation, and if you have any questions, if you want to talk about anything, I'm here.
Excellent. Thank you for presenting that and drawing attention to it. Appreciate that. Any comments, questions from commissioners? Excellent. Any public comment? Okay. So now we're going to move on to our last item, which is item 17, commissioner comments and proposed future agenda items. Any commissioners have comments, suggestions for future agenda items?
I've lodged mine already.
Okay. Commissioner Ortiz?
I just want to say that Commissioner Baker, since this is the last one, I have enjoyed working with you and much success with the new job.
Thank you, Commissioner Ortiz. I've really enjoyed working with you and all my colleagues, for sure. So.
Yeah, I think we.
Oh, but I'm going to be.
Yeah. I was hoping we could delay this as much as possible, right? And keep you as long as we could. Yeah, so I don't know where to begin. While I only was able to serve with you for about 10 months, I had been following your career prior to that and just so impressed with your dedication to public service. It's really astounding and something that every Californian should value and aspire to. And that's whether, your time in the Assembly, FPPC, and your new position with the UC Center, your desire to give back is just incredibly laudable. And thank you so much for doing that. As far as what you bring as a commissioner, I just think it's so important to highlight the level, your attention to detail, the focus that you put on this position. I'm really impressed with all our commissioners, and of course, I just thought it was worth, noting your interest and diligence in getting to the bottom of whatever issue that we're looking at to build consensus while also making sure that the viewpoints of diverse groups in California are still represented. With that, thank you. Thank you on behalf of all my family who's all interested in, in seeing what you're going to do next. I've let them know you're not going to be at their next meeting, but they're always interested to hear what you say as the different items. Yeah, they're big fans. Any other commissioners? Commissioner Wilson?
Yeah, well, Chair Silva, you're a very hard act to follow, so I'll try my best. But no, I
You're great too. Don't let anybody take that away.
Well, you're not the chair, no. So, no, seriously, just I want to comment on what Commissioner Ortiz and Chair Silva had to say. I've had the opportunity to know and work with Commissioner Baker over the years, not only on this commission, but previously when she worked, when she was a member of the California State Assembly. And I could just tell you that she is a class act, hardworking, and when you talk about, someone who's dedicated to public service, she exemplifies the best of what public servants should be all about. And as a committed public official and more recently as a member of this commission. It's been an honor to work with you, and you're also on the working with UC, and I'm on a UC advisory board, so I'm not like following you around or anything like that. But you've been an honor to work with, and I wish you the best in your future endeavors.
And I'm not going to try to beat all that, but I just agree with that and say, I've only had one meeting with, okay, I know you from the assembly, and yes, I already had respect for your public service, and I agree with all those things. But you're going to leave me in one meeting. I've already seen you. I've already been following you and your comments. It's been so helpful and just so insight. So I think I'm going to miss you at the very least.
Thank you to my great colleagues, each one of you, for your very kind words. Thank you, Commissioner Ortiz. It's been fun to sit next to you, fellow Alameda County person. And thank you, Chair Silver, for the great, very kind words. And to Commissioner Wilson. It's been a delight to work with you. 8 years, and including on this commission. And for one whole day, I'm glad we got a chance to serve together. This commission is in great hands. It's such an honor when you get to do something for the public and to be entrusted with that. You hope you've been effective, constructive, and diligent, and each one of you is that 10 times 10. And I just think it's great. I'm very grateful to the staff. They work so hard, not only answering questions, some of which come out smoothly and some of which don't. And so grateful for how responsive and diligent, how you not only work hard with the resources that are provided to you, but with the public scrutiny, media scrutiny, and our scrutiny. I'm very, very grateful for that responsiveness. This commission has great people working on it, and the mission is good. And so thank you for teaching me. I learned a lot from my colleagues, every one of you, including past commissioners that have already moved on to great things, and from the staff. So I'm very appreciative. I will look fondly. What I'm going to do for several hours on a Thursday afternoon and morning, I may watch a commission meeting. So, but very grateful to you and wish you well. It's good. It's a good group. Thank you so much.
Thank you. And we have a certificate that we would like to give you and then take some pictures.
Pictures and everything. Wow. Yeah. Oh my. Well, thank you. That's wonderful. Thank you so much. Beautiful. Great. Thank
Excellent.
you. Do we get to sit? We do it after? Do we do it?
Yeah, should we adjourn and then we can take pictures?
Good, yes.
Okay, so I'm going to move to adjourn. Second. Okay, Ms. Vo?
Commissioner Baker?
Aye, and thank you.
Commissioner Brandt?
Aye.
Commissioner Ortiz?
Yes.
Commissioner Wilson?
Aye.
Chair Silver?
Aye.
Meeting adjourned.
Okay, I think that's a record.